over prior to coming into court today. Additionally, Your Honor, I did file 2 motions for intervention and move conviction on each case with regard to that, as Ms. Skarupa does qualify for that program. She has never been convicted of a felony offense or even a felony offense of violence with regard to her criminal history. Ultimately, these are not felonies of first, second, or third degree. Drugs were a leading factor involved in these offenses, Your Honor. And she does suffer from mental health issues. She was diagnosed previously with generalized anxiety, major depressive disorder as well. I believe that intervention and move conviction would substantially decrease the likelihood of any criminal activity and reduce any future criminal activity with that respect. And Ms. Skarupa is willing to do anything that entails her in any type of program that the court may deem necessary. Thank you.
All right, so as I reviewed this report, why would I accept a guilty plea on the obstruction case?
Your Honor, with that regard, I previously talked to my client with regard to that situation. I know at that time she wasn't receiving medication she informed me of that are helpful to clarity with regard to her mental health. She's now receiving that medication inside the jail. I talked to her after that interview with that respect. She does not consider this case as garbage, for a lack of terms. She understands the severity that's involved with it, and she will tell you that today.
Well, I mean, her statement to Ms. Crook is that this offense is bullshit and only agreed to intervention because you were not fighting for her, which I don't believe, by the way, just as an aside. But if she thinks this case is bullshit, then she doesn't think she's guilty of any of that offense. And so I'm wondering why I'm not in the habit of accepting guilty pleas from people who do not believe that they're guilty. So why in the world would I do that in this case?
Your Honor, I'm guilty.
Well, then why did you say the case was bullshit?
Because I was medicated and just irrational thinking. But what I did, in the woods was silly. Shouldn't have even been there. I did what I did, and
exactly what did you do?
I was in the woods hiking, and I ran.
You were in the woods hiking.
Yeah, and I ran from the police. I got scared, so I put them in danger and myself. I did get hurt, which was also.
So you weren't at that house at all?
No.
Okay. So you guys got to help me in this thing, okay? Because as I read through this report, there's a call from a road worker working nearby who says this van or this car, whatever it is, showed up 3 separate times that day, littering the property with some garbage. Sheriff's deputies get called, go investigate, look in the house. It's clearly somebody's been in the house. There's broken windows, broken doors, open doors. It sounds like the zoning inspector should be over at this property figuring out what's going on over there. But things are disturbed. There was a male all dressed in black who went a separate way from you when you got there this time. And so I don't know what the hell's going on here.
Yes, Your Honor. So my understanding of everything, and this is speaking with my officers and the victim, is that Mrs. Scrubba's van, the defendant's van, was parked there 3 different times that day.
Why? Why was your van parked there 3 different times that day?
I had somebody else was driving my vehicle at the
Who?
time. His name was George Alb. I don't even talk to him anymore. He wasn't.
Why was George Alp driving your vehicle 3 different times that day?
Yeah, I can't speak on his behalf, and I do not.
Well, your car.
Right.
Did he do it without your permission?
We didn't even have communication. His cell phone wasn't even working. I know he dropped me off like near the middle school down the street so I could just be in the woods because, again, just nature hiking. So he called me after he had left my van to tell me he left it where he left it. So I was completely unaware of the spot that he had left it.
He left it in front of the house,
Right.
and you were in the back of the
And
house
when I
when the
got up
police saw
there
you.
with the police,
Right.
I seen where he left
None
my
of
car.
this makes any sense to me. None of this sounds like it's true.
Well, that's the truth.
Well, it's not, okay? So why were you there 3 times that day?
I was not there 3 times that day.
Why was Alp there using your car 3 times that day?
Your Honor, I don't know.
You don't know. Okay, where's Alp?
East Lake, I think, that's where he
What?
stays, I think.
Why was he dressed all in black? See, sounds like you guys were going in this house, is what it sounds like.
I wasn't in the house,
Okay,
Your Honor,
okay.
nor was he.
All right, how do you know? He was there 3 times that day and you don't know why, when he was there.
I mean, I spoke to him one time after this, and I haven't seen him since.
Okay. So nobody went in the house.
We can't confirm that, Your Honor. The construction worker at the scene did say that he did not see anybody go into the house, but I will say that when police arrived on scene, cleared the house, it's their understanding and my understanding that Ms. Greppel was at the property, hiding behind the house.
I know, I know what they said. I know what it says. I know what she says, but none of this makes any sense to me. And nobody knows who the guy dressed in black is other than what Ms. Scareppa told me is George Alp, if that's his name. Why didn't they find out who that was?
From my understanding, there was some follow-up, Your Honor. I don't know.
Well, they asked her who it was and she wouldn't tell them. That was the extent that they did anything.
And as far as I know.
So what's going on at that house that they get calls from there and there's been complaints of squatters there. And this is another squatter call apparently. Okay, so what's going on there that this is happening over and over again? And why aren't they finding out what's going on there? Because this keeps happening over and over again.
Yeah, I don't know the answers to that, Your Honor. I do know that it is a frequent problem and there is evidence of people being in that house quite frequently, such as sleeping bags and things of that nature being on the floor. But again, I can't say that the defendant was there.
You know, the simple answer to repeated squatter calls would be, why doesn't the owner secure the house? And then it wouldn't be a problem. Is that something that the Concord is trying to do rather than waste time of these guys running out there every time George Alp and his crew go out there? I mean, what the hell's going on here?
So I do know when I did speak with the victim when he was here briefly in the United States, in Ohio, he did say at one point he did secure the house, but when he came back, the door there was some kind of barricade in front of the door, and when he came back, the barricade was no longer there.
There's a lot of, I don't know what's going on here. There's a lot of shit going on that nobody seems to be interested in. And I'm curious as to why this thing with her record was even bound over in the first place. So I don't know. I mean, sounds to me like you ought to go to trial on this thing. So you're hiking, your story is you get dropped off, have nothing to do with this house. You were simply dropped off to hike in the woods. The police call your name and you run and they chase you. Is that obstruction? Where's the obstruction? Based on Ms. Skorupka's view of the facts, is there obstruction in that view of the facts?
With her hiking through, it's my understanding that if the police had reasonable suspicion to detain her and she did not stop.
Okay, she's hiking. I'm not talking about their view that she's at this house, abandoned house. And what she's telling me is she's not guilty of obstruction. And how do I take a guilty plea if the person doesn't admit guilt to the offense? Not to a made up offense, okay? We're not, this isn't a speeding case where we're gonna avoid 2 points and have a loud muffler instead, okay? This is exposing herself to a felony conviction potentially. So why would I accept a guilty plea based on what she tells me happened here?
Your Honor, I believe she would go in a little bit more detail about the encounter with regard to what had happened. Ultimately, we did have conversations about that, and I believe she would tell you a little bit more.
Besides the fact that when they called my name and I hid, and then when they called me out and I ran,
Why would you hide
doesn't scare
if you're
me.
just hiking through the woods?
It scared me. Why? I don't know why there was cops there.
So were you doing something you shouldn't have been doing and you were concerned that the cops were there?
I was high.
Well, so what? What does that mean?
Just
See, this is where we get to another problem that we have here, okay? Because what you're trying to soft sell me is that you had nothing to do with a trespass in that house or being there multiple times during that day when you didn't have a right to be there or in the house, okay? And now you're trying to give me some half-assed story, okay, that you were just hiking. Now then you hid and you didn't come out, then you ran. And that you're trying to give me something to hang my hat on that allows me to find you guilty or to agree, okay, that there is sufficient facts to support a guilty plea in this case. That's what you're trying to do. So nobody's being honest with me, which I'm used to, because whenever I sit here, nobody's honest with me, okay? So that doesn't matter, okay? But I can't accept guilty pleas without a complete admission of guilt.
Your Honor, I was on the property.
I know you were on the property, okay? Sounds like from what you're telling me, you were on the property by mistake because you were just hiking in the woods, okay? And I'm guessing that you weren't on the property by mistake, that you and whoever Johnny Cash was, all dressed in black, okay, were going to that property and doing whatever, all right? And you got caught. That's what I'm guessing.
This is just besides the point and not really a fact of the matter, but he would always wear black. And it was pointed out to him several times that he looks inconspicuous all the time, wherever he was. So
Pointed out by who?
me, friends,
Okay.
people he hangs out with.
See, now you're telling me that you know more about George Alp than just an occasional he calls and uses my car. Okay. So I can't, I mean, I've been out here for 20 minutes and I'm not getting straight answers. Okay. The guy just used your car 3 times. Okay. You don't really know him. And now you know him and you tell him not to dress in black and your friends tell him not to dress in black. So you got to have a conversation.
Your Honor, I never said I didn't know
You
it.
got to have a conversation. Because I'm not going to accept a guilty plea based on this conversation. Okay. So she wants something. All right. And maybe the problem is she probably hasn't been along through the system enough to know what a good lie is and a bad lie is from the standpoint of getting away with it. Okay. So if she's not going to be honest with me, Okay, now I'm not gonna put her on intervention.
All right.
More details with regard to the instant offense if she may.
Such as?
Your Honor, I've been told that George Alb has a past of trespassing, which actually I was completely unaware of. But that day, we had discussed this property. I did have him drop me off to enter into the woods, which took, it took about a 20-minute hike to get to the perimeter of the house. Now, I'm from Concord. I grew up in that area. So on my bus route, younger, I'd seen this immaculate house. Just beautiful. But recently, taking my daughter to Auburn, well, it's Lamouth now, I had noticed that it was dilapidated, overgrown, and there had been talks that it was empty. So I was in the backwoods. He had called me, said he left my van there. And I was upset with him that he had left it there. So by the time he called, I started walking up the hill. And I don't know if he went in to the house or not. Honestly, I do not know. I was told that he had been seen by people, and I started walking up the hill. I heard the police, sheriff's department yell. I did hide. When they did get into the backwoods, they called me out because I was crouched down, hiding, scared, obviously scared. And I ran from them. Tasers, I stopped. And then we all ascended up the hill to find my van. There was stuff at the end of the gully. So I don't, if that was him getting stuff from out of the house. So, I'm guilty of being there. I'm guilty of being a part of whatever he was trying to do.
Well, what was he trying to do?
And apparently get stuff from inside the house.
Apparently, I mean,
There's a bunch of stuff sitting out. I did find like little trinkets on my walk. It looked like it was stuff the kids may have played with. They were like all scattered about the hill. I did put those in my pocket. To, I don't know what else I would find,
you
Come to
didn't
find him gone.
You didn't find those trinkets scattered about the hill.
There was,
Okay, you did. What time of day was this?
about 1 PM, Your Honor.
In April?
End of April, yes. Yeah, there wasn't snow. I found like a little fairy leg and figurine, and
So what about this Alb character?
he's had problems with his parents and trespassing on their own property that I knew of. And that was the only case that I knew of with him.
How long have you known him?
Over a year. I met him through my brother. And he would just come around every once in a while, hang out. He was homeless, so I let him stay at my house sometimes.
Where do you live now?
I live in Painesville
Where?
with my brother and mother. No longer on Hawthorne.
What is your mental health diagnosis?
They said I was dual diagnosis, but I suffer from depression and anxiety.
How long have you been diagnosed with that?
About 5 years,
And what treatment have you had for that?
none.
Why not?
I've just been medicated, and I actually went off my meds
Well,
about,
where'd you get the medication if you weren't treated for it?
I had recently started going back to the doctors. And it was like August. And I just got my meds because I knew my mind wasn't right. I had been off of my meds prior to August for almost a year. And I could tell the difference. My family could tell, my friends. I was just irrational.
Would that have anything to do with the meth?
Yes, Your Honor.
Where'd that come from?
It's a long story. My brother suffers from paranoid schizophrenia, and he is a not long time, but he used meth as well. And I had him stay with me because he was also homeless. And I wanted to help him. And I made the stupid decision of trying this drug to see what it was about. Yeah. Worst decision I could have ever made.
Okay, when was that?
About July of 2024.
So you had never used drugs before that?
I mean, I was smoking marijuana, and I've tried cocaine.
And how long have you been using those?
Marijuana,
Anything?
quite often.
How many years have you been using marijuana and cocaine?
Marijuana, probably since I was 18. It helped subside emotions and anxiety. It calmed me down. The cocaine, not till I was in my 30s, maybe a little bit in my 20s, but definitely more so in my 30s, probably frequently before the meth.
So you're telling me that that was that's when you first tried meth because you thought with your mental health issues and your cocaine use and your marijuana use, you were just curious as to what this drug was all about.
Honestly, yes. It was affecting my brother. I
How
wanted
was it
to see if
affecting your brother?
I wanted to see if it was his mental health or if it was the drug. I wanted to try to relate to him, to try to help him, which doing the drug obviously wasn't the way to go. And
You knew that from the start.
well,
You couldn't possibly have thought
I
that
didn't know what else to
that
do.
using meth would have been a good idea.
I wanted to relate to my brother, Your Honor. I wanted to help him. He's a paranoid schizophrenic who wasn't medicated. I didn't know how else to help. We've tried every option for the last 21 years.
Well, how about if you start with helping yourself?
Yeah.
Before you try to help somebody else.
And I had hit rock bottom so quickly.
Okay.
And I,
All right, so then you, once you started using, if that's when you started using, you kept using. So now what?
I realized that I couldn't help him.
Okay, forget him. I'm talking about you.
I know.
Now what? And part of the problem is what you just told me is you live with him, okay? That's the next problem we have to address. So now what for you?
I kicked him out.
Well, you just told me that you live with your mother and him.
Well, yeah. No, that's my older brother. I have 3 brothers.
All right. What are you gonna do?
I have
How
3
old are you
brothers.
now?
39.
Okay, so what are you gonna do Because you've got no felonies on your record. Okay.
I don't ever want to go back to that drug or any drugs, Your Honor.
All right, so how are you gonna do that?
By getting a system, a network of sobriety people, I wanted to actually, before I had gotten the drug charges, I wanted to enter into an IOP program on my own accord because I knew I had a problem that I didn't want to have anymore.
So
I
did
had
you-
lost my
did-
job, I lost my
Did you
house.
do that?
I hadn't, I gotten in trouble. So I was advised that I should probably try to get into that program, but everything kind of just snowballed so quickly. I was getting evicted out of my house. So I was packing up, trying to figure out what to do with that. And then my older brother, not the schizophrenic one, is who I live with, and my mother. I have 3 brothers. So he let me stay with him while I was, moving out, and then obviously now homeless. So I was wanting to get a job at Meyer, IOP program, going to AA meetings. I have a very close network of friends that do actually go to AA meetings quite often. My father was taking, who he's here right now, was taking my schizophrenic brother to AA meetings as well, and I hadn't stuck my feet in the ground to just do it yet. But I know that this was something that would benefit me immensely. Alliant, there's many rehabs that I was looking into, New Beginnings, Square One in Ashtabula, which is where the network of my friends go to AA meetings. They're involved with taking people from treatment facilities to meetings. Alliant, which is located in Shaker Heights, they are a mental and drug rehab, a very well-renowned mental and drug rehab facility. There is a secretary there who went there and is a huge advocate for it, who's been sober for 6 years. She loved the program enough that she's back there working. I even thought about maybe doing social work at Lake and Geauga Recovery Services. I can't do the social work, but
Forget that.
yeah,
Okay, you can't do social work because
no, right,
you can't take care of yourself.
right. I need to get better. That's the most important part. And the rehab with the mental and the drug, I got a lot to uncover.
Did you tell me that you took your daughter to school somewhere in that area?
Yeah,
Where?
Lummuth Middle School.
Okay. How old is your daughter?
She's 14. She stays with her dad.
How come you didn't? How come the first I know about you having any children is right now? Because,
She doesn't stay with me.
all right, well, didn't you discuss that with Ms. Crook when she was doing the report? You told her you didn't have any children.
That's true.
Why did you tell her that?
Because she, well,
Huh?
I wanted to leave her out of it. She doesn't live with me.
Okay, so what? So what? So,
I don't really even take care of her right now.
okay, well, she exists, right? See, this is the next problem. I don't know what else there is. I'm supposed to, Ms. Novotny wants me to put you on an intervention plan. And the intervention plan is to address whatever ails you so that you comply with the plan, so you complete the plan, so you don't get felony convictions. That's the point, okay? Doesn't do me a damn bit of good to sit out here and extract information from you that's important information that would lead me to put you on a plan that's going to accomplish the end goal. So this has been nothing but an extraction exercise since I've been out here from you about what you did, where you're at in your life, what else exists that impacts you. So how the hell am I supposed to implement a plan if you refuse to give all the information?
I was told by inmates to leave my daughter out of it.
You were told by what inmates?
Inmates in the jail.
Okay. How many times have you been in jail in your life?
This year,
No. How
3
many times in your life have you been in jail?
I was in jail in 2005 once,
For how long?
maybe 12 hours.
Okay. And then what else?
This year, 3 times. The first time 15 days, second time 12 hours, and now I've been in there for 30 some days.
Okay. So in the process of this whole thing, how long have you been represented by Ms. Novotny?
Since April.
Okay. So you made the conscious decision to listen to these idiots in the jail and take the advice of these. Why are they in jail?
Because they broke the law.
Because they can't live by the rules of society. And you've got yourself a good lawyer here trying to help you, and you're listening to these nimrods over here. Why is that?
Scared?
Scared of what?
I don't know, Your
You
Honor.
don't know. You don't know.
Honestly, I don't know. More involvement with trouble. I don't want more trouble than.
So I don't know what you're all about as I sit here.
Just
I know you've got mental health problems that you've refused to treat in the past. I know you've got drug addiction problems that you refused to treat in the past. Both need to be treated. I don't know all the other factors that go into it, okay?
Your
Because
Honor.
external factors affect that, okay? There's external factors out there. Okay, one is your daughter. I don't have the slightest idea where she lives, who she lives with, how often you see her, what she's like, because these dipshits tell you to leave her out of it. Okay? You refuse to acknowledge the existence of George Alb, who's a known since I've come out here the first time. I found out that he's a chronic pain in the ass with law enforcement. Okay, you're hanging around him. You short shrift what you know about him, how you know him, when you hang around with him, how long you've known him. Okay. I don't know what other external factors out there, other people that you hang around with. Okay, because you pretty much. I don't know who's David Shipley.
He's my boyfriend.
Who is he?
I mean, he's my boyfriend. I met him.
Okay, what does that mean? Where does he work? Does he live somewhere? How often do you see him? Another external factor. Does he use drugs?
No, Your Honor. I did
Okay.
meet him while I was, doing the drugs.
How did you meet him? If he doesn't do drugs, how is it that you were hanging around him while you were using
Okay,
drugs?
so we first met and we're using.
Okay,
And
see, what I want here,
Yes.
okay, is we're not gonna continue this hearing today. We're gonna do this hearing on another day, okay?
Okay.
You're gonna go back, you're gonna talk to Ms. Crook,
okay,
and you're gonna quit the bullshit.
Okay.
Give her honest information, okay? Give her information that you refuse to give so far to her and to me and your lawyer. Because if you have any hope of being on an intervention plan, then you better tell me everything that I need to know for a proper plan.
Okay.
Because if you don't, and I put you on a plan, sure as shit, you'll be back here again having violated. And you'll be convicted. And you'll continue to spiral downward. Okay. When you go over here, stop listening to the morons in the jail. They're in jail for a reason.
Wow. We're back. Congratulations, and I hope everything went well.
It did, thank you.
It did? I mean, the ultimate goal was achieved.
Yes.
Okay, all right. So, all right, and I'll just ask, because of whatever's in the water that people are changing their names.
It's the same name.
It's the same name? God bless you. All right. Mrs. Enda, can you start us off?
Good morning, Your Honor. And then on behalf of the people, Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, we'll make this waiver and appoint it to public.
Oh, boy. Mr. Brown, I wore my Maryland red for you. Go ahead, sir.
Good morning, Your Honor, and congratulations, Mr. Laura Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you, sir. And the court, for its part, also does not believe that there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. The court does call the case of the people of the state of Michigan versus Romeo Smith.
Good morning, Your Honor. Actually, Lonnie Belvis with the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, Your Honor. I don't believe that
Yes.
he is he. Okay.
Mr. Smith, can you state your name, please? Okay, you might have to do that for me again. I think you broke up.
Muhammad Martinez Smith.
Thank you, sir.
And Your Honor, my understanding is that he's still incompetent, but restorable at this time. I believe the last report we got was back in either late August or early September. He's still being treated at the CFP, however, so we would just ask for a little more time.
The last report I have is August 21st, dated August 21st.
Yes, that makes sense, Your Honor. Yep.
All right, did people have any additional information?
Your Honor, we would simulate to that continue to report the finding of being incompetent, but likely to retain competent or restorable return competence. That's the court just gives the jury date.
All right. The defendant remains incompetent but restorable. I will set this problem is our trigger dates are gonna roll into the holidays, so we're gonna give you something close, but we'll move it if we get a report in.
Certainly.
23rd.
Yes.
Okay. All right. I'll adjourn the competency hearing in this matter to December 23rd, 2025.
My birthday.
Oh, it's not.
It is.
You're like a Christmas baby?
Yeah, kind of.
Surprising. In a lot of work. I'll explain why. I probably shouldn't do that. All right. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Carlos Edwards.
Good morning, Your Honor. Victoria Burton here on behalf of the people.
Good morning, Deputy Chief. We missed you.
I missed you.
Well, thank you. All right. Who's on this? Pardon? Oh, really?
Your Honor, I'm sure she is walking through the door.
No, Cannon, there is no telling where she is.
I saw her in the hallway working.
Yeah.
It's just had to make her way inside to continue that hard work.
Where is she?
Right there, Judge.
Stephanie Cannon on behalf
Well, good morning. You
Mr.
just come up and
Edwards.
say your name. You don't even say good morning.
Your Honor, the goodest of mornings to you.
You realize that you had an attorney defending your absence.
Yeah.
Yes, Chief
Yes.
Deputy Prosecutor.
I had the best, Your Honor, for the,
No, not them.
oh.
They were putting you under the
They threw me
bus.
under the bus?
They were putting you under the bus.
Did
Ms.
this
Burton
honorable-
Harris was defending you.
My girl, thank you. Thank you. Your Honor, on behalf of Mr. Edwards,
Mr. Edwards, can you state your name, please?
Carlos Edwards.
Thank you, sir.
Your Honor, I actually did not have the opportunity to meet with Mr. Edwards. When I called the facility, I am not on any sort of listings, so I need to get on some listings so I can visit with him. I am asking for just a 2-week adjournment. My intent will be able to see him hopefully by Tuesday.
He's in MDOC.
Yes, he's at the Central Michigan facility.
Right, but I guess if I'm looking at a 2-week adjournment, my concern is that, as I understand the process, there has to be an application and an approval process, and that hasn't occurred in that brief period of time.
Okay.
That's been my experience. I mean, I'll give you a 2-week, but I don't think it's gonna work. Why don't we do this, October 16th? I'll give you, yeah, let's do that. Probable cause conference will be adjourned October 16th. And then hopefully you can start that process and we'll at least have some indication as to what we do.
Thank you so much, Your Honor.
All right, thank you, Mr. Edwards.
Yeah, you're welcome.
Court does call the case of the people versus Carista Riopel.
Morning, Your Honor. As well as for the people.
She's in.
He's here.
Oh, morning, Your Honor. Mike Gaddy, Assistant Public Defender for Ms. Riopelli. Could you state your name, ma'am?
Carissa Riopel.
Thank you.
Your Honor, I think we have this, I have some news I need to deliver to Ms. Riopel that I think will settle this case. I will personally go out there. I had planned on doing it before I went off on medical. I think we are in a position, Ms. Londi has tendered an offer that I think will resolve this matter. I'd ask to adjourn it one more time so I can drive to
Okay,
DOC and actually go over this with her.
drive down, it's like 5 miles.
Exactly.
Okay. Will October,
I know the direction, so apparently others may.
will October 9th work?
That'll be fine, Judge.
All right. And I'm going to adjourn your probable cause to October 9th, 2025, 9 a.m. Bond will continue. All right.
Thank you.
Thank you, ma'am. Court does call the case of the people versus Andre Flores Nava.
Good morning, Your Honor. Victoria Burton here, appearing on behalf of the people.
Good morning, Your Honor. Michael Vincent, appearing on behalf of Flores Nava.
Your name, sir?
Andres Flores.
Who's here with, oh, there she is. Okay. Thanks. I just wasn't gonna go ahead unless. All right. I'm still, it's like PTSD. All right, what are we doing on this case?
Your Honor, this is date and time set. Probable cause conference. We're asking for a waiver, circuit court.
All right. Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr. Vincent,
Yes, Your Honor.
you acknowledge receipt of the information
Yes.
waived reading. Your client stands mute at this time.
Yes.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea as to both counts. Pre-trial reset for
October 8th at 1:30.
October 8, 2025, 1:30 for Judge Conlon.
Your Honor, could I address the bond?
You may.
What is his bond at right now?
I have his bond set at $10,000 cash sure.
Is there any chance to make it 1,000, 10%? He has a hold out of Wayne County. We hope to get him out of that hold. It's circuit court.
Well, you mean you want him to go to Wayne County to deal with that?
Yeah, but I want a bond on him, so he's earning time. If we could have $1,000 bond, 10%.
Well, I would have some concern about him going to Wayne County because we have to make sure to get him back. What my problem is.
I'm asking for a bond, just a lower bond.
I heard you. I mean,
He'll come.
I understood what you were saying, but
I don't, so I'm glad you do.
any response from the people?
We're gonna leave it to the discretion of the court. I do understand the intent of the request. I also understand the concern the court has about his return, should he find out and go to Wayne County. But people also share in that concern, so I will leave this to the court's discretion.
He'll come back, Your Honor. If not, I'll go get him.
You know what?
I'll go get him if he doesn't come back. I
Oh,
will.
I thought you said we could take you.
I'm too old.
All right, I'll give it a shot. I'll grant the motion to modify his bond. I'll set his bond at an amount of $1,500. I'll give a 10% privilege.
You're right, $1,500, no 10%?
1,500, 10%.
Thank you, Your Honor.
All right. Thank you.
Don't make me get out. All right. Don't talk on the phone.
Court does call the case people versus Jason Poland.
Andrew Manis for the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Kiriakin on behalf of Mr. Jason Poe.
Miss you too. Or they did. I did.
Oh, Your Honor, I missed you.
Mr. Poley, he's got to get somebody done, you know. Sir, can you state your name?
Jason Alampoli.
All right, thank you. What are we doing on this case?
Your Honor, we respectfully request that both of these matters be set for preliminary examination.
And what date do we have?
October 7th.
So discovery is complete. I'm sorry.
To my knowledge, Your Honor, there is one body cam video that I've already requested from the people earlier this week. I don't think that it should stop us from proceeding.
And so there's an understanding that if that's not provided, that won't be a basis for the adjournment.
Understood, Your Honor, yes.
All right. People have their witnesses available the 7th.
We will do our best, Your Honor.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. That is before Judge Perry.
Thank you, Judge.
Thank you. Bond continued.
Love it, I'll take him back.
All right, take care, sir.
Thank you, Your
Court
Honor.
does call the case, People versus Marvin Sullivan.
Michael Vincent on behalf of Marvin Sullivan. Mr. Sullivan, what's your name on the record?
Marvin Sullivan. Thank you.
We need a date for a prelim exam, Your Honor.
Discovery is complete.
Yes.
I believe that it is, Your Honor.
Yes. It's been a long time at Pittsfield Police going over everything. And Amanda says we have everything.
All right. Would people have their witnesses available the 7th?
October?
Yes.
I can attempt to do that, Your Honor. I do believe that we're gonna have a handful of witnesses, so.
I don't know what that means. You won't be or you will be.
I'm gonna attempt to have everybody there, yeah.
Your Honor, if I may, the Pittsfield detective stated they would not be available that day from the October 6th to the 17th.
Thank you.
You're welcome.
Thank you.
You're welcome, John.
After the 16th.
All right. You said the 17th.
Correct. The 6th
Okay.
to the 17th.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. That's before me. Bond will continue. Court calls case People versus Anthony Alexander.
Andrew Banish for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Alexander. Mr. Alexander, can you please state your name?
Anthony Alexander. Thank you. You're asking for an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned to October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Take care. Court calls case People versus Andrew Gendy.
Morning, Your Honor. Andrew Santa, appearing on behalf of Mr. Gendy.
Jennifer Douglas for the people.
Present. Is your client present, Mr. Banta?
He's in lockup, Your Honor.
Oh, he's in custody. I'm sorry. So we have him, yes. I didn't see the purple tab or anything. Sir, your name?
Andrew Gendy.
All right. All right, what are we doing?
Your Honor, I would ask for an adjournment on this PCC until the 16th of October. At that time, if we are unable to resolve the matter with the people, we will be waiving our preliminary exam.
Any objection to the adjournment?
Your Honor, the people will not object to that.
Probable cause conference will be adjourned October 16, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Philip Carrick.
And then on behalf of the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Carrick, who's approaching.
Good morning, Your Honor.
Can you please state your name?
Yep,
Philip Carrick.
P79229, appearing on behalf of.
Okay. That was not for us. Which is. Okay.
Not for us, Judge. We're asking for one more adjournment, Your Honor.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Montez Miller, 2 cases.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller on case ending in 1435, Your Honor.
And Edward Drugas on behalf of Montez Miller in 1434.
Your name, sir?
Montez Miller.
What are we doing?
Your Honor, we are just asking to set the matters for preliminary examination today.
Correct.
With regard to both cases, is discovery complete?
To the best of our knowledge, Your Honor.
Yes, Your Honor.
People have their witnesses available the 7th.
We'll try for that date, Your Honor.
Preliminary examination in person, October 7th, 2025, 9 a.m. That is before Judge
Fleischer.
Fleischer.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Bond will continue. Court calls case of the People versus Naya Lee.
The members on behalf of people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Miss Lee. Miss Lee, could you please state your name?
Naya Lee.
Why is Constantine lurking? That bothers me.
I just thought I'd hang out for a bit. Just thought I'd hang out for a bit.
What are we doing in this case?
Your Honor, I developed a conflict of interest through the investigation of this case, and I'm asking to step out and ask for Miss Constantino to step in.
That's why she was hovering.
That would be why I'm lurking, Judge.
Based on that representation, I'll permit your withdrawal. The manager's time counsel has indicated Ms. Constantino will not have this case. All right, go ahead.
Thank you. Christina Costantino on behalf of Miss Lee. Given that I was quite literally just brought formally on board this case, I would.
What, you're not ready? No, go ahead.
I could be, Judge.
Yeah, all right.
I would be asking for an adjournment to get up to speed and have some conversations with my client.
All right. Ma'am, did you state your name?
Yes.
Will the 9th work for you, Ms. Constantine?
Yes, Judge. Thank you
All
very
right.
much.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the cases of the People versus Michael Siegel.
Ready, Your Honor.
2 cases.
And then on behalf of the people.
James Fifelsky on behalf of Michael Siegel, both files. State your name for the judge, please.
Michael Anthony Siegel.
Your Honor, we are here on PCCs on 2 files and a bond violation.
Yes.
I'm requesting the court adjourn everything, including the bond violation. My client is prepared to sit tight. I understand there are new charges coming down that are related to the bond violation. So it would seem to make sense to put all this together and see where we can go with it from that point on.
And that's correct, Your Honor. We authorized 2 more counts of aggravated stalking. I've signed the warrant request. We're just waiting on the script to be arraigned on that case. But it should be up.
You don't know whether they've been sworn to.
Not yet, Your Honor.
Yeah, okay. I guess that's what I was getting at. Well, if we're looking to put everything together, then I will adjourn the probable cause as well as the bond violation.
Your Honor, and my client is telling me he still has the tethers on his ankles. Does the court just want to have those removed while he's in custody?
That's not up to me. It's what they're gonna do.
Okay.
They come and get them, they'll come and get them.
All right. Thank you.
So since he's in custody, I'll adjourn it to October 16th. I would go one more week out, but let's see if we can get everything done. October
Works for us.
16th, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you. Court calls case People versus Harold Couch.
Good morning, Your Honor. People.
And good morning, Your Honor. Joseph.
No.
Joseph Hall, excuse me.
Oh.
Joseph Hall appearing for it on behalf of Mr. Couch.
Oh, no.
Better or worse than Mike, Judge, you know, I mean,
Yeah, but
don't answer.
I was getting used to Mike. It's like, yeah. It's like, then you're here. You told me you were gonna be here. Boy,
Is that a promise?
there was joy on my face.
Good morning, Your Honor. Joseph Hall appearing for it on behalf of Mr. Couch.
Your name, sir?
Harold Couch, Jr.
Thank you. All right, what are we doing?
Your Honor, I've just been retained. I believe the court may have signed the substitution, if not this morning.
Yes.
And so we'd request an adjournment to allow me to review and obtain discovery.
9th or 16th.
Oh, that's a great question, Judge.
You need to demand it.
It appears
Takes too long.
the 9th is gonna work better. Just long enough.
October 9th, 2025, 9 a.m. Bond will continue.
Thank you so much, Judge. Great to see you.
Good seeing you, sir. Court calls case People versus Bosie Smith.
Send on me, Dr. People, Your Honor.
It's rushing.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Smith. Mr. Smith, can you please state your name for the record?
Boise Smith. Thank you.
Thank you.
What are we doing?
Your Honor, we've received the discovery in this matter. At this time, we'd be moving to set this matter for a preliminary examination.
Wait, people have their witnesses available October 7th.
We'll try our best, Your Honor.
Preliminary examination in this matter will be in person October 7th, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you so much, Your Honor. Have a great day to you and your wonderful staff.
You do the same. Court does call the case of People versus Kaida Matson.
Good morning, Your Honor. Recording representatives appearing again on behalf of the people.
Good morning, Your Honor. Again, Michael Vincent on behalf of Madsen. State your name.
Kaida Joe Manson.
Thank you.
Your Honor, we need a small adjournment. We're lacking the videos in this case.
All right. Think that everything regarding that can be accomplished by the 9th? Well, I know.
Yes.
I already gave you the 9th. You don't have to look at her. That's why I didn't ask her. I'm just asking, can you get what you need done by the 9th?
Yes, if we get the videos quick.
Well, the
I share
videos
your
be-
anxiety.
Well, can you get the videos to him sometime before the 9th so that he can see them?
Yes, Your Honor. If we don't have them in our possession, we can actually OIC for them and try to get them to you expeditiously.
Thank you so much.
Don't give them to Amanda.
Get them to me, not to me.
Do not let Mr. Vincent handle it. All right. Probable cause conference will be adjourned October 9th, 2025, 9 a.m.
Thank you.
Bond will continue.
Yeah.
Thank you, ma'am.
You're welcome. Thank you, Judge.
Yeah.
Yes.
He does?
Yes, but not at the moment. Wait a minute.
Court does call the case People versus Jessica Yoder. It's great to watch that Goldstein gave up his seat.
Me again, Judge. Christina Costantino on behalf of Ms. Yoder, and I am in case number NA 1282FY.
Stephanie Cannon on behalf of Ms. Yoder on the remaining two matters.
And your name, ma'am?
Jessica Yoder.
All right, what are we doing?
Judge, this is the date and time set for PCC. We would be asking to have a preliminary exam in this matter. Discovery is complete to my knowledge.
And that's on 8. You're on 8-2.
I'm on 8-2.
Your Honor, I am asking for the same thing as for the remaining two matters.
And there's going to be no objection to them all being heard on the same day.
I have no objection, Your Honor.
I have no objection either.
All right. People have their witnesses available the 7th. All All right, preliminary examination in person, October 7th, 2025, in all three cases, 9 a.m. before Judge Fleischer. Bond will continue.
Thank you, Judge.
Thank you so much, Your Honor.
Court does call the case of the people versus Adam Atkins.
Victoria Burton here is again appearing on behalf of the people.
Lebo. Come on up, sir. You're good. Your name?
Adam Atkins.
He was sitting right there. Now Miss Apple's sitting.
Your Honor, Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Just already state your name for the record. Sorry. Your Honor, we are asking for an adjournment. Do you have the green sheet?
I do not.
No, okay. I think Mr. Lebo put that right here, but we're asking for an adjournment. It appears that we are waiting for some mitigation and some discovery as well as some treatment information.
All right. Probable cause conference, October 16th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case of the people versus Gary Taylor. All three cases.
Present for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Taylor on all three matters, Your Honor. I'm sorry, except for 5191, I apologize.
Yes,
Didn't mean
James
to-
Bifelsky on behalf of Mr. Taylor on 5191.
Got it.
In that file, we're asking.
Name, sir?
Sorry.
Gary Taylor. Thank you.
I believe on all files, we're asking for the court to set this for preliminary examination.
That is correct, Your Honor. Sorry, I didn't mean to exclude you.
All discovery is complete.
As far as I know, yes.
To the best of our knowledge, Your Honor.
People have their witnesses available the 7th. Preliminary examination in person will be set October 7th, 2025, 9 a.m. That is before Judge Perry on all three matters.
Thank you very much, Your Honor.
Thank you. Bond continue.
Thank you.
Thank you.
Court does call the case of the people versus Tanisha Akins.
As well as for the people. Assistant Public Defender Hannah Apple. If we see for the record, Tanisha Akins.
Thank you.
You're welcome. Your Honor, we are working out what I believe will be a misdemeanor resolution. However, we need to finalize the restitution amount. So, and then Ms. Akins needs to make payments towards that. If we could have.
She needs to make payments.
She needs to pay the restitution in full before the misdemeanor will be offered.
That's correct. We're just trying to nail down the exact amount. Your Honor.
Yes,
Would we be able to at least nail down the exact amount in a couple of weeks?
I would think so.
I think that's realistic. Thanks, Your Honor.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Okay, thank you, Judge.
Thank you.
I will be in touch.
Court calls case people versus Diego Rodon Cardo.
And is that on behalf of the people, Your Honor?
Good morning, Judge. Kyle Riddell filling in for Bill Amadeo on behalf of Mr. Rondon Cordon.
Your name, sir?
Diego Rondon Cardone.
Okay, you have any objection to counsel stepping in for your attorney of record?
No, sir.
All right, thank you. Thank you. What are we doing?
Your Honor, speak with Mr. Amadeo. We are just asking for a 1-week adjournment or whatever the court's next available date is to work out a global resolution in this matter.
Well, is 1 week going to be enough time to do that? Thank you.
Sure.
Probable cause conference, October 9th, 2025, 9 a.m. Bond.
Thank you, Judge.
Thank you. Oswego County, okay. There's a gentleman who is signed in from Oswego County Jail. Can you give us your name, please, sir?
Robert Greenshields.
He's not. You heard his name.
I heard his name.
Sir, you're not on our docket. Do you know who you're supposed to be appearing in front of?
No, sir.
Okay. Do you have a case in Washtenaw County?
Yes.
Trevor Mayville for the people, Your Honor. I believe he's set for a 3 p.m.
Yeah, there at 3 p.m.
Yeah, with Mr.
And Mr. Kilowog's not here. All right, they signed you in early for, did we not know? We didn't know he was in custody. All right, sir, is Mr. Kilowog expected? Try to get through to Mr. Kilowog, see if we can get, what we're gonna try to do, you're on our docket at 3, but since you're signed in right now, we're gonna try to get your attorney here if we can and try to deal with your matter while you're here, okay? So it may be a little bit of a wait, but we're gonna work on that, all right?
Okay,
All right, thank you. Court does call the case, People versus Malik. Is it Arcidi?
Malik Saidi, yes, Your Honor.
All right.
Stephanie Cannon on behalf of Mr. Sadiq, Your Honor. Victoria Burton here is appearing on behalf of the people.
What are we doing?
Your Honor, may we approach for just one moment?
One of you can take a guess. No, come on. Nine AM without objection, bond continued. Thank you.
Thank you.
Court calls case of the People versus Michael McLean.
Victoria Burton here is appearing on behalf of the people.
Good morning, Your Honor. Tina Sack, on behalf of Mr. McLean. Mr. McLean, please state your name for the court.
Michael McLean.
You're requesting an adjournment.
Yes, Your Honor.
It's a discovery issue, so probable cause conference will be adjourned October 9th, 2025, 9 AM. Bond
Your Honor.
continued
Your Honor, I'd like to make a bond argument.
briefly.
Your Honor, given the nature of this offense, I'm asking for the modification to his bond to a personal bond.
Response.
Leave it to the court's discretion, Your Honor.
Is he in treatment at all?
I was on my way to assessment, sir, at Sparrow. And I got in.
Pardon?
He was on his way to an assessment, he said.
And what happened?
This,
Intervened.
this. Your Honor, I can approach with an explanation.
I want to hear it. Come on.
No.
You don't want to come, you don't want to explain?
No.
You don't want, so.
For HIPAA reasons, Your Honor, I can't go on the record. I cannot go on an open record, but I have consent to disclose privately.
Well, then I'm not changing any. I need to know. That's an unusual circumstance.
With the permission to approach, it would bring
I'm
clarity.
saying, come on up. I want to hear it. I'm gonna deny the defendant's motion to change his bond. However, I will release the defendant to inpatient treatment. If you prepare the order, I'll sign that.
Thank you, Your Honor.
All right, thank you. Court does call the case of the People versus Brandon Kelly.
For that is the people.
Any luck with Mr. Kilowog? All right.
Yeah, Michael Gaddy, Assistant Public Defender on behalf of Mr. Kelly. I see this Zoom screen. I don't see Mr. Kelly.
Mr. Kelly? Oh, they're taking. Got it. Mr. Kelly, can you state your name?
Brandon Kelly.
Thank you. What are we doing?
Your Honor, I've had a chance to speak with the prosecutor. I spoke with Mr. Kelly yesterday. I was going to report to him this morning, but he wasn't able to be brought up. I was able to meet with him yesterday. I'd ask the court, I think we're kind of at an either or set or waive situation here. I would ask the court to adjourn this 1 week so I can have that conversation with you, Judge.
When next available date's the 30th. Probable cause conference will be set for September 30th, 2025, 9 a.m.
Thank you, Judge. May I approach with the green sheet?
Yes, bond continue.
I'll come and visit you, Mr. Kelly. That was 9:30, correct? Judge?
Yes. Court calls case People versus Annie Oglesby.
Tina Sachs on behalf of Annie Oglesby.
Your name, ma'am?
Annie Oglesby.
Thank you.
Your Honor, I'm requesting a preliminary exam date. If you remember, Your Honor, there's another case that was set on the 30th for preliminary exam, if possible.
Before who?
I do not know. I was on.
So she has another case set on the 30th?
Yes, and it's actually a companion case.
Got it. Can I, Miss Oglesby has another, and Miss Oglesby has another case on the 30th?
Yes.
Who is that before? Okay,
I'm sorry, who is it, people?
so you'll be ready on that? Would
Yes, Your
people have their witnesses available on the 30th?
We'll try.
All right.
Thank you.
Preliminary examination in person will be set September 30th, 2025 at 12 noon. That is before me.
And Your Honor, may I make a bond argument?
You may.
I'm still waiting.
Your Honor.
Yes.
Your Honor, at our last hearing, I made this argument that Ms. Oglesby now will be staying locally, so she will be able to test. She's been incarcerated since the night of the event and reincarcerated after not testing. But now that we've confirmed that she will be staying in Pittsfield Township, she will be able to test with community corrections. And she has already started programming while here. So there is a plan in place.
I'm going to deny the request. I don't need a response. Understanding that she's got a preliminary examination coming up in 5 days, and I'll reconsider any request after that point.
Okay, thank you.
Thank you. Bond will continue. Court calls the case of the People versus Louis Atkins.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins.
Larry, okay.
Your Honor, we are asking
Just put
for.
a Y.
No, I know you, it's not your fault. All right, go.
Your Honor, we're asking for an adjournment. We are completing some mitigation information that we'd like to propose to the prosecutor's office. If we could have some time to complete that.
Probable cause conference, October 16th. Will that be enough for you?
I hope so.
All right, October 16th, 2025, 9 a.m. Bond continue. Thank you. Larry. Court calls the case People versus Johnny Bankhead Williams.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bankhead Williams. Say your name for the record.
Johnny Bankhead Williams.
Thank you. Your Honor, we are asking for an adjournment. We are missing video discovery still.
Got it. Probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case People versus Amanda Corwin.
Christina Costantino appearing on behalf of Ms. Corwin, who's coming up to the podium now, Judge.
All right.
Amanda, can you state your name for the court?
Amanda Corwin.
Thank you.
Judge, this is the date and time set for PCC. I was just recently retained by Ms. Corwin, and I will need some time to obtain discovery and review it with my client. So we would be asking for an adjournment of the PCC. And I do have a green sheet.
All right. That objection, probable cause, October 16th, 2025.
Thank you, Judge.
Bond continued. Thank you.
Thank you very much.
Court calls case People versus Roderick Bates.
The public defender cannot be carried out on behalf of Mr. Roderick Bates, who is approaching. Mr. Bates, state your name for the record, please.
Roderick Bates. Thank you.
Your Honor, we would like to set this matter for preliminary examination.
Discovery is complete.
To my knowledge, Judge, yes.
People have their witnesses available on the 7th.
And Judge, if I can address bond briefly, please.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. That is before Judge Fresh Hour. Yes, as to bond.
As to bond, Judge, Mr. Bates is currently in custody because he failed to appear for his last probable cause conference. And prior to this, he had been coming to court and he had not missed a date. On the
I'm not going to allow you to do that only because of the complications, because of your citizenship. I think it's best that you talk to an attorney before you do anything, because I have no control over what the federal government does, and I don't know what their response is going to be to this. So you know that my understanding is there is a holder on you right now. So it's my opinion that you need to at least talk to an attorney before.
I already have an immigration attorney.
And who is that?
It's through Justin Bartlett and Weigel. It's their one of their lawyers, their immigration lawyers over there.
Okay.
They can't do anything for me.
They can't do anything for you?
And until I go to Butler. So once ICE picks me up from here, there's nothing they can really do immigration wise.
Until you get down there?
Until I get to Butler, yes, sir.
Officer Vretos, I'm looking at your recommendation for treatment. Is it your recommendation that he be continued on ILC?
Yes, Your Honor. I was hoping, despite Mr. Pena's, this being not his first ILC violation, but I think this is his third. But Mr. Pena and I spoke about him going out once he gets everything taken care of. If he gets the opportunity to come back into ILC supervision, we spoke about him getting his own insurance, which is something him and I have gone back and forth trying to figure out the insurance component to treatment, because otherwise it's just all out of pocket. We spoke about, I think it's in his best interest to get insurance anyways. It's better to be insured. So I told Mr. Pena, if he's on board for giving this a shot, I was good with continuing on ILC, set this for a review hearing in 45 days, or maybe after he figures out the immigration side of things.
Mr. Pena, what is your current status?
I am a legal permanent resident, Your Honor.
Okay. All right.
Green card.
So this is what you want to do, is waive your right to counsel in this hearing. And then you've heard the recommendation of Officer Vretos, which I am inclined to follow.
Yes, Your Honor.
All right. So in essence, then he would be released today from our jail, which means he would then be transported to Butler County by immigration, correct?
Correct,
And
Your
then,
Honor.
and then you would get your hearing with the Department,
Okay, Homeland Security.
Homeland Security. All right. All right, give him a waiver of counsel form. Do you have other convictions that you have to deal with?
No, Your
Are
Honor.
there any other warrants?
He does actually have a warrant out of Butler County area.
Oh, yeah.
One second, I have it right here.
It's okay. It's a
Okay, it's a misdemeanor. I'm not, maybe they'll just deal with it if he's in their custody. And then I think one out of Hamilton County for another, it's like a minor misdemeanor.
25.
But this is his only felony
Okay.
on his record.
Thank you. All right, Mr. Pena, this is your signature, sir?
Yes, Your Honor.
And you can read and write, and you understand what this document says.
Correct, Your Honor.
You understand that you, by signing this, you're waiving your right to have an attorney represent you in this proceeding.
Yes, Your Honor.
And you understand that if you can't afford an attorney, the court will appoint one for you at no cost. You
I
understand that?
Yes, Your Honor.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Okay, so what I'm going to do is I'm going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I'll accept that, okay? Now, with regard to this allegation, and there's been an amendment to the probation ILC violation, and you want to read that?
Yeah,
Why
I
don't
can.
you read the violations just to refresh our recollection?
Okay. The defendant is in violation of ILC condition number 7, and that the defendant tested positive for cocaine on an oral swab on 2/28/2025. The defendant verbally admitted to using cocaine on March 1st, 2025, and marijuana on March 4th, 2025. And on 9/11/2025, the defendant submitted to a urine test that was preliminarily positive for cocaine. The defendant denied use, and the sample was sent to the lab for confirmation. On 9/17/2025, the sample came back confirmed negative for cocaine. However, the lab identified the sample as intentionally diluted. And then special condition number 16C, to date, the defendant has failed to complete treatment as ordered at his hearing on ILC on October 31st, 2024.
Okay, do you understand those allegations?
Yes, Your Honor. I do have a question though.
Yeah.
One of the violations on there, I believe, was that I didn't let my probation officer know that I had a law enforcement contact.
Right.
Correct.
I removed that.
Oh,
It's
okay.
not on here anymore.
Gotcha.
Yeah, we took it.
She updated the allegations, okay?
Yes, Your
Now,
Honor.
with regard to what she read and what she read only, do you admit that, or do you want to have a hearing on whether or not those things are true?
I admit it.
Okay, the court's going to find that you have violated the terms of your ILC. At this time, Mr. Pena, I'm going to, despite this violation, I'm going to continue you on ILC. I will order you released today. Once you clear up everything that you've got going on in Butler County and with the Department of Homeland Security, I need you to immediately report back to Officer Vretos. You understand that?
I will do that, Your Honor.
Okay. And then I'm going to order you to engage in treatment with the coach. Is that right, coach?
Yeah, well, I was gonna help figure out insurance first and then go from there and figure out who will cover his private insurance.
All right. So you got to stop using illegal drugs, right?
Yes, Your Honor.
There's no drugs, no alcohol, no marijuana. You cannot use those things right now. Okay. Let me just make some notes here. Just make sure you get back in contact with Officer Vretos once you have cleared this up, okay? Because you're jeopardizing your ability to stay in the United States. I think you know that. So you have an attorney that's handling that issue for you, right?
Yes, Your Honor. I do.
Okay. Do you have any other questions for me?
No, Your Honor.
All right. Good luck to you, Mr. Pena.
Thank you, sir.
I'll be right. I'm gonna come talk to you. Or, huh?
Yeah.
Or are you just taking back the holding stuff? Yeah. Okay, I'll be right back there. Okay. 31 days.
31 days. Release.
On Brenner?
Yeah, I mean, he's.
Yeah, bring him in here.
Probably a while.
I thought I had the date of his last hearing written down. 2 hearings ago, he came to court late. And his case was called, and then a bench warrant was issued. We submitted a request for a bench warrant recall. However, once that recall was granted, I don't think that Mr. Bates received the next date for his hearing, which subsequently caused him to miss the last probable cause conference date. I spoke with him and I put on my Judge Simpson hat.
My phone was off.
Pardon?
We did not
My
have.
cell phone was off, and I didn't get an email or nothing.
So we did not have any contact information for him, well, any working information at the time.
Go ahead, I'm hearing your argument.
So, Your Honor, I put on my Judge Simpson hat and I asked myself.
Wow. Wow, you have fun?
I borrowed it from Mr. Brown.
Oh.
I said, what would Judge Simpson?
He has one? What would Judge Simpson?
That's correct, yeah.
Yeah, okay. So we have bracelets for sale. Anyway, go ahead.
So I asked my client, Your Honor, all of the questions that I could anticipate the court asking him. He does take responsibility.
No, I got more.
I'm sure.
Okay.
We can never, we'll never meet that standard, but I tried my best, Your Honor. And he took responsibility. He said that he tried to contact our office. He was contacting the attorney who he had worked with originally. Obviously, that was not the attorney on the case. They did not receive that information. However, I informed him that
to put another conference on. I know he filed the notice of self-defense. I told him I anticipate filing a motion for 404B evidence to come in. So I think it makes sense to have another conference to discuss some of those evidentiary issues ahead of trial. I just received some police reports yesterday that I'll need to review to determine what exactly I anticipate going in that 404B. I sent them to Andrew this morning in supplemental discovery. There are a couple of jail calls I need to provide him. And so I think another conference makes sense.
Okay. Mr. Brenner, I'll allow you to go speak with Jennifer and set that again in a few weeks, maybe a week to two, a week and a half before the start of the first trial, okay?
Very well, Your Honor.
All right, you wish to, anything else? Mr.
Nothing on that issue.
Okay, and then you'll work out the civilian clothing issue if he's not released today?
Absolutely, Your Honor.
Okay, Mr. Brenner, you wish to be heard on the issue of bond?
I do, Your Honor. A couple of things. I know, obviously, there's a domestic element to this. My client's indicating to me that his wife is telling him that if he is released from jail, the son is going to leave the residence. So I wanted to pass that along to the court. Additionally, my client has limited financial resources. He is retired. He's on Social Security. And so he does not have the ability to post a large monetary bond. I would ask the court to consider reducing his bond to something on the minimal side, with the understanding that he's a long-term resident of Warren County. He intends to fight this case to the fullest extent. He will be present at all future court hearings. And honestly, I think based on my conversations with him, he's not going to have any problem following a no contact order. He would frankly like one himself with the alleged victim in this case. And so, Your Honor, I would ask the court to consider reducing his bond so that he can be released while the case is pending.
Ms. Nicholson?
I met with the victim last week. Was not my understanding that he is vacating the premises. He lives there, is living there and assisting his mother at this time. And when I spoke to him last week, there was no intent on him leaving the property. I know that the defendant, when this case was in the lower court and in the process of being bound over and awaiting grand jury, repeatedly told his wife on jail calls that she needed to get the victim to leave so that he could return to the residence. There have been multiple occasions throughout the jail calls where he has instructed his wife to tell the victim things. Not all of them directly related to this case, but there is a TPO and a no contact order in place. And he is still attempting to pass messages through. The son, when I met with him, conveyed that as well, that he is getting messages passed to him. And so if he is doing that in the confines of the jail,
Both the state and the victim have concern about his ability to follow a no contact order if he were to be released. But I think the primary concern is he does not have a place to go in the lower court. And prior to indictment, there was an OR bond with a monitor, and there could be no residence verified. And so he was not able to be released on that bond. And I don't know that any of those circumstances have changed. I'm due to meet with the victim again tomorrow, but he certainly knows how to be in touch with us. We discussed this at length last week, and he indicated that he was not planning on leaving the residence. That's where he resides.
So, do you have a place to go?
No. He does. My older son said he could come there. And that's exactly what my wife told me.
Okay. Your Honor, my client, obviously, I think anytime we have a domestic situation, it gets a little fishy sometimes, but my client does deny, attempting to pass any messages along to his son. Obviously, he speaks to his wife. His wife lives with his son in this residence where this incident took place. And so, obviously, whatever his wife is doing as far as communicating with this, based on what your dad said or whatever, my client has no control over that. But he is indicating to me his understanding is that, if he is able to be released, that his son will be living with another family member.
And if not, if he doesn't live somewhere else, what's your client? Where's he going to go?
My client at that point would have nowhere to go, Your Honor. I think he would have to attempt to find another family member at that point.
And Your Honor, I can certainly have Ms. Kennard attempt to call the victim right now to see if that position has changed. But as to and as I said, there are jail calls I need to provide Mr. Brennan.
I don't need to get into that right now. All right, what I'm going to do today is I'm going to grant an OR bond with electronically monitored house arrest. That way, community corrections will verify if he has a place to go or not. So if he does not, then he doesn't get released. Mr. Costa, I'm going to caution you when I issue a no contact order. No contact means no contact. That means you don't talk to somebody, you don't call them, you don't send them text, you don't send them messages, you don't like their Facebook posts, and you certainly don't have somebody else contact them on your behalf. Are we clear on this?
Yes, Your Honor.
So if there's videos, because these jail calls are all recorded. If there are recordings of you telling your wife to tell your son something, that is a violation of my order, and I will revoke your bond again, and we will not have this discussion a second time. Do you understand that?
I do, Your Honor.
You follow my orders, or you sit in jail. So that will be a condition of your bond: electronically monitored house arrest, no contact with the alleged victim in the case. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Brenner?
No, Your Honor.
All right, thank you all.
Yes, sir. I don't even know why we could just get that. You're all good to go.
Number is, I gave him our number. I told him that any attorney in our office would have been able to help him with that information. He does now understand. He doesn't have a criminal history to my knowledge, Your Honor. And the only reason that he's got this bench warrant was because we were not able to get in contact with him. Prior to this, he had been to all of his hearings until somehow that mix-up happened.
I have two questions.
Yes, Your Honor.
First question is that hat that Mr. Brown let you use?
Right.
Did it have a block M on it or a Maryland
Maryland.
Okay, all right. So just checking. You had to check, really?
No, I knew it.
Okay. The other thing is that I'm trying to figure out. When did you submit the request?
I believe it was submitted the next day or that day. He indicates that he came to court. They had informed him that the bench warrant had already been issued, that he had missed his court date. And then that request was submitted at that time. Let me grab it.
Do we see that?
Oh, it's the 21st.
Was it on the 21st?
I was supposed to be here and I was out late for.
I show the protocol. Same day.
So from the 22nd, it was canceled that same day
Yeah.
because of that, and then it was reset to August 7th.
Yes.
And
Yeah,
then
and I
he
got
didn't
no
appear
notice.
on August
She
7th.
did not appear on August 7th, Your Honor.
Response from the people.
You're up to the discussion of the court, criteria, I think we did explain, for, just hearing what had occurred, so, I will leave it up to this.
She was just bouncing that out to see, we think this will work. Thank you, Ms. Douglas. Since previous bond was $25,000 personal card. Okay. Given all of that, I will reinstate defendant's bond at a $25,000 personal recognizance bond so that he can be released. So I'll grant the motion. You understand that, sir?
Yes, thank you, Your Honor.
And Your
When
Honor,
are
can
you
we get
supposed
the,
to come back to court?
Oh, I will show up every time.
when?
When? Don't give him a hint.
Yes, Judge.
You said the 7th, right?
I dare you not to show up if I'm letting you out. October 7th, 9 a.m.
Thank you so much, Your Honor.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Matthew Brown.
Here, appearing again on behalf of the people.
Christina Costantino appearing on behalf of Mr. Brown, who is present via Zoom. Mr. Brown, can you please unmute and state your name for the court?
Yeah, Matthew Tyler Brown.
Thank you.
Judge, this is the date and time set for PCC. There is still some outstanding discovery. We have had some discussions about that discovery and about specifically what is missing and our plan for getting me that discovery. So given that, we would be asking for an adjournment of the PCC so that I can ensure discovery is complete.
All right, would the 9th be enough time for you to get the information?
I would think so. Would the 9th be enough time?
I hope so. What she's looking for is not in our possession, so we need to request it from the agency.
All right, I'll give another week on that. October 16th, he's not in custody. So October 16th, 2045, 9 a.m.
Thank you.
Thank you, Judge.
Thank you. Bond continue.
Thank you.
Thank you, sir.
Yep.
Court calls case People versus Eric Brackman.
Trevor Maybell for the people here on.
Good morning, Your Honor. Assistant Plug Defender Davia Lieb on behalf of Mr. Brackman, who is standing to my right. And Your Honor, we are waiving today. Mr. Brackman, if you could sign.
Your name, sir?
Eric Brackman.
Thank you.
And Your Honor, we are waiving with an agreement that they will not be adding a habitual.
Is that a correct statement from the people?
Your Honor, I didn't hear that last statement.
We are waiving with an agreement, you'll not be adding the habitual.
That's true. I do believe that the defendant needs to be arraigned on the amended.
That is true.
On the added count two.
As well as the amended count 1, Your Honor.
Okay, have you seen that?
I have, and I've reviewed it with Mr.
Wait for
Brackman, and we
review
do.
that.
Yes, Your Honor.
And how does your client plead to?
We stand muted this time.
I'll indicate defendant arraigned on. Thank you.
Thank you, Your Honor, and we will not be adding the habitual.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
October 9th at 1:30, Judge Slay.
October 9th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you. Okay. Court does call the case of the People versus Malachi Harris, AKA Malachi.
Christina Costantino on behalf of Malachi Harris. Mr. Harris, can you please state your name for the court?
Malachi Harris. I told you that's what.
Hands out of your pocket. Yep, you're good.
All right. What are we doing?
Your Honor, we have reached a resolution in the case, but we do need a bit more time just to facilitate some plea paperwork.
Okay.
So we would be asking for just a brief adjournment of the PCC to accomplish that.
October 9th, 2025, 9 a.m. bond.
Thank you,
All
Judge.
right. Thank you. See, I got it this time. It could have been one of those days otherwise. Court calls the case, people versus Daryl Frederick. No, they're writing on the front of the files.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frederick on all matters, Your Honor, that being one.
Yes, thank you. Your name, sir?
Daryl Frederick.
Thank you.
And Your Honor, we are just asking to set this matter for preliminary examination. My understanding, Your Honor, in talking with Ms. Douglas is that there potentially might be an outstanding video. We do understand that that's not going to be a reason for an adjournment should we go to PE and not have that.
Said it correct.
Correct, Your Honor. We have video still on the video. I have requested a video. This is actually the second time we've requested it, but there are video stills that were turned over to defense, but I am trying to see if we can get the video itself.
All right. Okay, I'll set it, but there's that understanding that that would not be the basis of an adjournment. That
Thank you, Your Honor.
video outstanding. People would have their witnesses available to 7.
I'll write an order for that, okay?
Preliminary examination in person, October 7th, 2025, 9 a.m. before Judge Perry. Bond will continue.
Thank you, Your Honor. And Your Honor, would the court consider an order for release to treatment if I were to send one in on behalf of Mr. Douglas? Or Frederick, I'm sorry.
What is my response typically?
Generally, yes, Your Honor.
Brown's hat.
Generally, yes, Your
What
Honor.
would I say to that?
I just wanted to say that on behalf of my client, Your Honor.
Okay, I will sign an order for release.
Thank you. I will get that in today, okay?
Thank you.
Thank you.
You're welcome, sir. Court does call the case of People versus Michael T. While I wait, sir, Mr. Killowald has just arrived, so we'll call your case momentarily.
Christina Costantino appearing on behalf of Mr. Teague. Mr. Teague, can you state your name for the court?
Mike T.
Thank you.
Judge, I was just I recently became involved in Mr. Teague's case. So I would be asking for an adjournment to obtain discovery and have conversations with my client.
October 16th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court calls case of the People versus Alua Gillis.
Alexander, on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Gillis, Your Honor.
Your name?
Hello, Gillis.
All right. She's waving.
She is waving, Your Honor. If we could briefly approach, I just have something that I need to talk to the court about real quick.
Okay.
Thank you.
Okay, yeah, I just want to go through myself.
Counsel on the last matter approach, please.
We proceed to exam. Discovery is complete to my knowledge.
All right. People have their witnesses available on the 7th. All right. Preliminary examination in this matter in person will be set October 7th, 2025, 9 a.m. before Judge Fleischer. Bond continue.
Thank you, Your Honor.
Thank you.
Yes.
Court does call the case, recall the case of the people versus Robert Greenshields.
Trevor Maison for the people.
Ready on Rob J. Cole on behalf of Mr. Greenshields. Mr. Greenshields, would you state your name for the record, please?
Robert Cloud Greenshields.
I have before me a plea form that indicates that the defendant would be pleading guilty to an added count to abuse of cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. However, there is the sentencing judge waiver box is checked, but it's a 1 case, so it's mine.
Judge, just a little bit of background. This was scheduled for 3 o'clock. I guess Otsego Jail didn't realize that. They have had him on at 9 a.m.
Yeah.
They were very gracious yesterday. They allowed me to talk to Mr. Greenshields. I went over his rights. Obviously, I don't have a signed waiver, but he understands his rights. He wanted to resolve this matter, pleading to the misdemeanor, and I appreciate the prosecutor's offer. So that being said, we have a plea agreement. It pleads to the misdemeanor of cocaine use, and the felony would be dropped. Is that a correct statement, Mr. Greenshields?
Yes, Your Honor.
All right. Mr. Greenshields, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, sir.
Robert Greenshields.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You went over an advice of rights form or your rights with your attorney, is that correct?
Yes, Your Honor.
All right, you understand that because of a trial, you're giving up certain rights that I want to make sure that you understand. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
All right. And because you believe that you're guilty of this offense?
Yes, Your Honor.
July 6, 2024, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you, if between the time of this plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules, that any evaluation or recommendation in this case, the court would no longer be bound by. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defense?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Judge, is it possible for an immediate sentence? He's going to be spent-
Anything is possible.
With you, yes,
That's
I
whether-
understand that.
Well,
Judge, I
You're
really
just
do.
gonna try to butter me up, so I'll do it.
Just a
No.
little bit, yeah. Do you being the considerate and kind judge you are, he's gonna be released, sentenced in
Have you worn the Simpson hat?
Pardon me?
Nothing. You weren't here. Go ahead.
He's gonna be sentenced in that county October 9th. I'm wondering if you would consider me.
On what kind of case?
I didn't get that far with him. What are you being sentenced on October 9th for?
Possession.
A felony possession?
Yes, Your Honor.
All right. So you don't be any objection to the court. How long have you been in?
Since August 6th.
So we got what, about 30?
Your Honor, the defendant was out on bond in that case at the time he committed this offense, and I think there's more wisdom in waiting to see what Oswego County does with him on the felony charge before sentencing him here.
Why?
Because that was a felony narcotics case, and this one was as well. And if he wasn't to get the appropriate sentence up there, I would be recommending probation down here potentially.
So you don't think they're going to put him on probation?
I don't know what they're going to do.
Again, Judge, you being the considerate judge you are, I'm sure you'll.
Well, I would, I mean, if there weren't an objection, I'd immediately sentence him because I think they're going to put him on probation because it's a felony case, but.
Well, I appreciate the offer they
seems to
gave.
think otherwise, so I'll just add this to my docket on what date. Set it for sentencing, October 8th.
Judge, can we go past that? I'm in trial October 6th with Judge Kunke. Can we go the weekend?
You two are wearing on me.
Judge, I understand. This is all new. I thought it was going to be here at 3:00, but that being said, can we put it out a little ways?
So you just threw that back at. What's my next date after? Will that work for you? October 22nd?
I'm sure that would be good.
Sarah, I'll set your sentencing for October 22nd, 2025. Well, when are you sentenced in the circuit court?
October 9th.
9th? All right. So October 22nd, 2025, 12 noon.
Judge, I'm just asking, does he have to, do I need to get him probation phone number so he can contact them, obviously? So they have a report for him, for you? Or we,
No.
You don't know?
Well, we'll let probation know where he is. And I think they'll try to reach out and make contact.
Okay, thank you for your
All right.
consideration and the prosecutor. Thank you.
Continue.
I'll be talking to you, Mr. Green Shields, okay?
Thank you, sir.
Let me know what happens after October 9th.
Let everybody know. If you get probation, then we wasted my time. Court calls the case, People versus Anna Gunderson. Wow. That was, well, yeah, that's sort of scary. I mean, not you. Well, yeah, you. It just like you popped out. I didn't know you were there. You didn't. Yeah, I know. You need to tell me where or what it is. Thought there was a deal, Alan. All right.
Ready, Judge. Torshell Fleischer, Assistant Public Defender on behalf of Ms. Gunderson.
Your name, ma'am?
Anna Gunderson.
Thank you.
Thank you, Judge. My understanding is Ms. Gunderson has a violation in circuit court as well. We're going to try and get her into some treatment. So we're asking for a brief adjournment to track both cases together and figure out a resolution.
When is
She
that?
was up yesterday for arraignment, so I'm guessing it's about 2 weeks. It will be knowing about 2 weeks out. So if we go 3, that should be fine.
So if I set this for the 16th, you'll know what has happened.
Yes, Judge.
Any objection to that?
No, Your Honor.
Probable cause conference in this matter will be adjourned to October 16th, 2025, 9 a.m. Bond continues.
Thank you, Judge. I will prepare an order for treatment if there's not one in the file.
I'm not signing it. Just because it's Feaster. No, I will sign it, of course. Court does call the case. People versus, their writing's getting like mine. Awani Abuka.
Trevor Maybell for the people here.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Abukaf, who is present and consents to appear via Zoom. Mr. Abukaf, can you say your name?
Auni Abukaf.
Your Honor,
Thank
I
you.
was just recently retained on this matter. I believe we're up for the first PCC. We're asking for an adjourned PCC date. I believe we have all discovery, but yes,
All right. Will October 16th work for you, sir?
certainly.
All right. During the probable cause conference, October 16th, 2025, 9 a.m. Bond continued.
Thank you very
All
much.
right. Thank you. Court does call the case of the people versus Damon Harris.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Harris.
Your name, sir?
Can you see? Oh, Damon Harris.
Thank you. Welcome back, counsel.
I know, it's my first time.
It's been a minute.
Yes.
All right, go ahead.
Yeah, and at this time, we'll be sending this matter for preliminary examination.
Both-
To my knowledge,
both
all
cases?
yes, in both cases. To my knowledge, all discovery is complete.
And would the people have their witnesses available on the 7th?
Your Honor, when it's appropriate, may I address bond?
It's a trick question. Preliminary examination in these matters will be set in person October 7th, 2025, 9 a.m. That's before Judge Perry in both matters. Yes, that's about.
Yes, Your Honor. In both matters, I'd be asking for reconsideration of a reduction in bond to a personal reconnaissance bond. Mr. Harris is a father to an 8-year-old daughter who he's been even assisting and taking care of from being in custody. He actually had to sign off some documentation with the assistance of my office to allow her to be able to go to school. She's currently under supervision of his sister. He would be able to reside locally with his sister if released. He does have gainful employment lined up also if released. So at this time, Your Honor, I'll be asking for consideration of a PR bond in both matters. I do know he does have a matter in the 14A3, 14A4 District Court that he does have a bond on, but he believes he'll be able to ask for that bond to be reduced at that next court date as well.
When is that next court date?
I believe it is October 6th, Your Honor.
But that bond's in place. What is that bond?
$2,000 cash surety.
At this time, we're gonna do it, I guess, backwards, because what I'm gonna do is I'm gonna deny the request for a bond reduction. Bond in these matters will continue since these are set for the 7th. If that's gonna be on the 6th, you can see what you can do about that bond, and then you can address that with Judge Perry on the 7th.
Yeah, understood, Your Honor. Thank you.
All right, thank you. Court calls case People versus Tiger Moore.
Trevor Mabel for the people, Your Honor. James Vitfelski on behalf of Mr. Moore, who is approaching. Please state your name.
Tiger Moore.
Your Honor, we are requesting an adjournment.
Where's the rest of his pants?
I got rained out, so it was mildew, so I didn't want to. I'm all wet.
He's homeless, Your Honor. His
Okay,
his
that's
only
where
pant-
that happened. Oh, and you got rained
Can't
on.
wear 'em.
And so you took those off and got something else.
Right, cast.
Okay, fair enough.
Best he.
I appreciate it. No, he gave me an answer. Nobody else ever gives me an answer. I appreciate it.
Your
He's
Honor,
forgiven.
thank you. We are still working towards a resolution. Mr. Mayville and myself had a conversation. We're asking for an adjournment.
All right. October 16th, 2025, 9 a.m. Bond will continue. Thank you, sir.
No problem. Thank you, sir.
Thank you very much, Your Honor.
Court does call the case People versus Edward Harris.
Andrew Van is the people.
Stephanie Cannon on behalf of Mr.
What's wrong?
Nothing, Your Honor. I'm strong.
Oh, hold on a second. He needs his hearing assist.
It's good to see you, Mr. Harris.
Can you hear me, Mr. Harris? Can you hear me? Okay, great. Can you state your name for me?
Edward Harris.
Thank you.
Your Honor, we're just asking for an adjournment of this matter so that we can see if we can get a plea on this case.
All right. Is this the only thing he's held on? I thought he was held on some other stuff.
Your Honor,
Yes. Thank you. He is under sentence. He's serving out a 1-year sentence. I believe his out date is in March, if I'm not mistaken.
March.
All right. So what I will do is probable cause conference, October 16th, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank you. Thank you, Mr. Harris.
Thank you.
Court calls case People versus Theodore Edwards.
Okay.
Oh, boy.
David I. Goldstein appearing on behalf of the defendant.
Did he get rained on?
I'm sorry. No.
I'm sure.
Your Honor, we talked to the fashion police. They passed it, but just barely.
They didn't pass that. Go ahead, there's no telling.
Your Honor, we have
No telling what I'll do because I don't understand.
Well, hopefully you'll
I'm
start by
headed
letting.
for it, and then let me put those up and go. Is that what happened?
Yeah.
Okay, that's a little weird. Go ahead.
Your Honor, we have executed a waiver. We're waiving it.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Absolutely.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of a copy of the information. When my client waives further reading, stands mute, asked that a not guilty plea be entered.
Defendant every waive formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
November 18th at 1:30 with Judge Simpson.
November 18, 2025, 1:30 before Judge Simpson. You gonna wear that same outfit?
No, I ain't gonna.
Oh, really? Why'd you wear it here?
Had to
Never
get
mind.
here on-
Don't even answer that because you're gonna get yourself in trouble. I haven't continued bond yet. Bond continue.
All right.
Next time, bring the whole with you. What? Sure. Court calls the case of People versus Evans. Sherbet.
Andrew Banner.
Oh, they just signed. Is that him?
System plug.
Sir, what is your name in the orange at
Evan
Livingston?
Sherbet.
Okay, that is him. Okay. Thank you, sir.
And Assistant Public Defender Dobby Leba on behalf of Mr. Sherbet. Mr. Sherbet, could you state your name, sir?
Evan Sherbet.
Okay, what are we doing?
Your Honor, I do have a green sheet. We're going to be requesting an adjournment for 30 days. Possible. Mr. Sherbet is scheduled to be released from the Livingston County Jail on the 15th, and he would be in a better position to provide some mitigation information at that time.
Any objection from the people?
Oh, yeah.
All right, you're set to be released on the 15th, sir?
Yes, Your Honor.
All right. Probable cause conference will be adjourned October 30th, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Paris Lester.
Senator Douglas for the people?
Mike Gaddy, Assistant Public Defender on behalf of Mr. Lester, who's here to my right. Judge, state your name, Mr. Lester.
Paris Lester.
Thank you.
Yeah, I think we have this matter all but resolved. We just need to do the paperwork. If we could have a very brief adjournment, we'll be able to get that this matter cleared.
Is this the only thing holding him or something?
He is under sentence till January 16th on another matter.
Probable cause conference will be adjourned then to October 9th, 2025, 9 a.m. bond continued.
All right.
Court does call the case of the people versus Tammy Meredith.
Victoria Burton Harris again appearing on behalf of the people.
Miss Meredith is here.
She's here.
Yes.
You sent Cannon to help? Really?
She volunteered, Judge.
Yeah,
She'll learn.
Yeah, no, she was actually successful. All right.
David I. Goldstein appearing on behalf of the defendant. State your name, Tammy.
Tammy Meredith.
All right.
Your Honor, in this matter, we have executed a waiver of a preliminary examination. It's her intention to waive exam.
I don't have a problem necessarily doing that, but you saw our progress report.
Miss Burton Harris made it available to me this morning, Your Honor. I did discuss it with my client. She acknowledges that she did have a dirty test and that she did use cocaine on that occasion. She didn't test again because she frankly didn't have the money. She did indicate to me that she does go to the VA 4 times a week, is it?
About 4 times a week.
And they test her there. So if she could sign if she could sign a release of information, she can test there and they'll provide that to community corrections.
2 things. First of all, if I had you tested today, would you be clean?
No, I'm being honest.
Why not?
Because I just kind of threw in the towel on this thing for a reason. Like this time of year is hard for me. I had a son that passed away, so kind of in depression a little bit, which means I spend more time at the VA because they keep a close monitor on me. So.
And that's out on Fuller?
Yes, at the VA hospital.
And you go there 4 times a week?
For different appointments and stuff, but I have talked to one of my caseworkers about intensive outpatient, which means I will be there 4 times a week just for that, which will interfere with none of my other appointments because they allow us to bounce around in the hospital like that.
What branch?
Air Force.
How many years?
4.
And right now you're just struggling.
Yeah.
You're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Oh, no. I got a receipt. Yeah, count 1 with 2 following.
Your Honor, my client and I we acknowledge receipt of a copy of the information. We waive its further reading. My client stands mute, asking a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
November 19th at 1:30 with Judge Conlon.
November 19th, 2025. 1:30 before Judge Conlon. All right. Here's what I'm going to do regarding your bond. Mr. Goldstein will tell you that my normal course would be that I would incarcerate you. I'm not going to do that.
I watch you on TV.
So you know what I do.
Wave to the camera.
No. And it's Meredith, here's what I'm going to do. I'm not going to do that because you're doing things that you need to do at the VA. So probably should, but I'm not going to. I'm gonna trust you. All right. And you're gonna go up before Judge Conlon, so if you don't do the right thing, then if it didn't happen here, it's gonna happen there.
Well understood.
Okay. All right. And as I say to every veteran that I know, thank you very much for your service.
You're welcome.
I am always aware I get to do what I get to do because of people like you.
Thank you.
All right.
You still teaching at Washington? I had your class.
You did?
Yeah.
When?
I graduated from Washington in 2015. So it was some years prior to that.
Prior to that?
Yeah, because you was at the old court. We went over there for ex credit.
Got it. Yeah, that was a long time ago. How was I as a professor?
Great.
Thank you.
Remember,
All
he
right.
changed his
So in
mind.
that case, bound continue.
Judge, I sent her over to Community Corrections to sign a release of information.
Okay. All right. Very good. All right. Thank you.
Okay.
Court calls the case People versus Gerald McKinney.
Allison, on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. McKinney, who's approaching now. Mr. McKinney, will you state your name for the record?
Gerald McKinney.
Your Honor, we're asking that these matters be set for preliminary examination.
Discovery is complete.
To our knowledge, yes.
People have their witnesses available the 7th.
We'll do our best, Your Honor.
Preliminary examination in person, October 7th, 2025. 9 a.m. before Judge Fleischer. Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Jermaine Mills.
Andrew Banish.
David I. Goldstein appearing on behalf of the defendant. I'll state your name, please.
Jermaine Mills.
Your Honor, Mr. Banis and I have been discussing resolution, so the court is aware there are 2 misdemeanor charges pending against Mr. Mills in the 15th District Court, which arise out of the same course of conduct. If you can give us about 3 weeks, we can get a global resolution on all the matters.
Probable cause conference, October 16th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Court calls case of the People versus Maxwell Nowak.
Judge Fleischer, for the people.
Judge, Marshall Fleischer, Assistant Public Defender. On behalf of Mr. Nowak. Please state your name for the record.
Maxwell Nowak.
Thank you, Judge. I did meet with my client yesterday. We did discuss this matter. I believe we'd like to set this matter for preliminary examination. I do believe discovery is complete.
People have their witnesses available the 7th.
We'll try for that date, Your Honor.
All right. Preliminary examination in person, October 7th, 2025, 9 a.m. That's before Judge Perry.
I have one thing, Judge. My client would like to go to treatment. Do I ask for that after the exam or before the exam? What's the best way to do that for?
Since he just showed up here. But he'd like to go to inpatient treatment, so you would just need if you file an order with me for release to inpatient.
He indicates that he is on parole with MDOC.
Right, that's what.
And
I do think something.
And his agent wants to send him to inpatient treatment, but she can't do that because this case is holding him. So.
Oh, I got you. Okay. So that order would be a little bit different, but if you just send it over indicating that those particular facts, I still won't have an objection to signing it if they want to send it.
Thank you, Judge. I'll get that prepared and send the draft over.
At this point, bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court calls case People versus Stephen Olazewski. Olazewski, I think. Oh, hold on. Apparently that last case we cleared to side of the courtroom. See ya. Your name?
My name is Stephen Olszewski.
Olszewski.
David
I
Igold.
looked at it and I said, it sounds different. Go ahead.
David I. Goldstein appearing on behalf of the defendant. Your Honor, well, we have discussed the matter, let's put it that way, and we do need some more time because there's some medical records I have to get. So we're asking for an adjournment.
Is that you?
No, that was not me.
No, not you.
Oh, sorry.
God, no, Your Honor. Not on this earth.
He'd have been running out the door, Your Honor. Could have been him.
Probable cause conference. You got to get medical, right? So, yeah.
The 16th will be fine, Your Honor.
You think it'll work?
Oh, yeah.
Okay.
Oh, yeah.
October 16th, 2025, 9 a.m.
Your Honor, there is one minor issue with regard to the bond. The drug testing was ordered, and he has been doing the drug testing. However, he has discussed with the people where he tests, if he could do swabs rather than urine tests. They've indicated they had no problem with it, but we had to get permission from you.
Any objection from the people in terms of that? Everybody's just looking around. Oh, you're just, okay.
Haven't had a chance to discuss this ahead of time. If that is something that's deemed okay with community corrections, I'll leave it in your discretion.
All right, well, I'll let people check with community corrections, have them send a communication to us to prepare an order. I'm not gonna have a problem.
Okay. Thank you, Your Honor.
Thanks for reading.
Thank you.
Thank you, Bond, and continue with the road testing. Court calls case of the people versus Evangelist Patterson.
And then on behalf of the people,
Assistant Public Defender Davi Leba on behalf of Mr. Patterson, who stands to my right.
Your name, sir?
Landis Patterson.
Okay, Your Honor, today we are requesting an adjournment in order to continue some negotiation. I did send a mitigation report to Ms. Zenda. I'm not sure if she's had a chance to review that yet.
Probable cause conference, October 9th, 2025, 9 a.m. Bond will continue.
Thank you. I did also want to address bond if possible.
Go ahead.
Thank you. Mr. Patterson is very eager to be released. He would like to get back to his job and care for his children. We'd be asking for a personal bond or a small cash bond with a tether. He has recently completed the Dawn Farm program in the jail.
He has?
Yes.
Yes.
Is anything else holding him?
Not to my knowledge, Your Honor.
Responding to people?
Your Honor, at this point, I would object, given that he failed to appear on this case back in 2022. And has finally come back around. I would ask that bond remain as set. This is a case involving RNOs in which he had to be carried, tased, et cetera. So I mean, at this point, I would ask that bond remain as set, given that he failed to appear years ago. And I would have concerns that he would return to court given that.
I needed that. I have nothing further, Your Honor.
How did he come back into custody?
Mr. Patterson?
Did I come back to custody?
He got picked up.
Yeah, I got picked up.
Yeah, so if you hadn't gotten picked up, the time you failed to appear in 2022, we still wouldn't see you, right?
I was saying release for the bond to tether.
Pardon?
I was saying like release to tether or with the bond tether.
You want to tether?
Yes.
Yes.
So that and you can disappear? No.
No, I'm saying
Motion for bond reductions denied, bond.
why it's on the ninth, instead of the second.
Thank you.
Because that's the next available date.
Court calls the cases of the people versus Man Davis. All 4 cases.
Ashley Lonnie Feltes for the people.
And Edward Hughes on behalf of Man Davis in 1167 and 1367.
And Assistant Public Defender Chinazi Carey. I can really, Your Honor, on behalf of Mr. Mann on the other.
I got a story for you, Judge.
I'm sure you do, because Mr. Davis is not here.
He is not, but he may be at the hospital. I understand there may be a bond violation in the public defender case, and the battery went.
Maybe at what hospital?
So Your Honor,
Because you're looking at Ms. Akinrule.
Well, she knew the hospital.
She's the one that told you that?
She told me. I
Okay,
thought it was a
let's go
good
with
story.
the story. You just sit
I
down.
thought-
Go ahead, Ms. Akinrule.
Your Honor, we have not been able to make contact with Mr. Davis. However, based on the bond violation, the GPS tether, I think the last place that it reported was at Trinity Hospital.
I recall seeing that. But we don't know if he's there now.
We do not, Your Honor. We do not. I'd like to see if I can send a social worker, investigator, or somebody over there, but obviously they won't give us much information over the phone because
Here's what I'll do in each of these cases. I'll issue bench warrants, 10,000 cash surety. I will have those warrants issued. Today's what date? I'll have those warrants issued the 30th. That will give you some time to do whatever.
Thank you, Your Honor.
Thank you. Court does call the case People versus Thierry Reynolds. Thierry Reynolds.
Assistant Public Defender Jay Bellinger on behalf of Thierry Reynolds, who approaches, Your Honor.
Your name?
Thierry Reynolds, Your Honor.
And Your Honor, we are just asking to set this for preliminary examination. Prior to doing, so Your Honor, I just wanted to make the record and that my client was offered and has rejected the following plea, that being if he were to plea, it would have to be up in circuit. That would be a plea to count 1, that's an R&O, dismiss count 2, dismiss count 3, and an added count 4 of attempted R&O. My client has rejected that. He wishes to set for preliminary examination at this time.
Is that correct, sir?
Yes, sir, Your Honor.
Discovery is complete then.
To the best of my knowledge, Your Honor.
People have their witnesses available October 7th.
I believe so, Your Honor.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. before Judge Fleischer. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case People versus Jacob Halfacre.
And people.
Your Honor, Michael Vincent on behalf of Jacob Halfacre, and may we approach? Over the
The client doesn't want to come out. Okay, come on, approach.
If I knew the answer to that.
What? Oh, you like, come on.
All right.
Your Honor, is it?
Okay. I'll just adjourn his competency hearing. I'll adjourn it to October 30th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus William Riddle.
Is that on behalf of the people?
Right down there.
Motion, please, to Assistant Public Defender on behalf of Mr. Riddle. Mr. Riddle, please state your name for the record.
William Michael Riddle.
Thank you, Judge. I've spoken to Mr. Riddle, and I've reached out to the people. My understanding is Mr. Riddle would like this matter set for preliminary examination, and I believe all discovery has been complete.
And would the people have their witnesses available on the 7th? Preliminary examination in person, October 7th, 2025, 9 a.m. before Judge Perry.
Thank you very much, Judge.
Bond will continue. Thank you. Court does call the case of the people versus Alana Bellows.
Assistant Public Defender, Cedric Simpson. Your Honor, is it possible for us to pass this matter? We have reached a resolution and I was still working on drafting. You want us to approach
You've reached a resolution.
with the people? Yes, Your Honor.
Okay, depending on the nature of that resolution, it's gonna depend on whether or not I can participate. I stated what can be a conflict regarding this particular. And
Okay.
hello, Ms. Bellows.
Hello.
And so, depending on what it is, if it's not something that council believes would cause any problem, it certainly is not going to be for sentencing at all. But then you guys can wait and I can handle whatever resolution.
Should we approach and let the court and let Your Honor know so we can decide?
Yeah, and then I'll pass the matter.
Okay.
Why don't you approach?
Thank you, Judge.
Says Charles Blake.
Your Honor. Assistant Public Defender Jay Bellinger on behalf of Derek Riles, who approaches.
Your name, sir? Derek Riles. Thank you.
And Your Honor, we are just asking to set both of these matters for preliminary examination at this time. To the best of my knowledge, discovery is complete.
People have their witnesses available the 7th.
We'll do our best, Your Honor.
Preliminary examination in person, October 7th, 2025, 9 a.m. before Judge Fleischer on both cases.
Thank you, Your Honor.
All right, bond continue. Got one more to do. Court does call the case of the people versus Charles Blakely.
Trevor Maybell for the people, Your Honor.
Thank you, Your Honor. Stephanie Cannon, on behalf of Mr. Blakely. Mr. Blakely, could you please state your name for the record?
Charles Edward Blake.
And Your Honor, we are going to ask that these matters be set for exam.
Don't have a problem, but you may want to, we're going to have to address his violations.
What
about intake?
You have to do one. You have to do it intake at community correction.
Okay.
Mr. Allen.
Your Honor,
yes.
And to be clear, he can go do the intake. My client is willing to walk over there now and do it intake. He's actually hard of hearing himself. So he has no problem doing this. He doesn't use, are you gonna test clean for the court?
Yeah.
Yeah, he doesn't do drugs or anything like that. He has no problem doing
He hasn't reported, he's done nothing.
I was unaware of that aspect of what we're doing here today. My client, he has no problem working with you, the court, or community corrections on this, Your Honor. This is his first and only ever offense. He's not familiar with this process at all. He's willing to go over to community corrections. He'll test clean. He will do the intake. He'll make himself available. He calls me all the time. So this is not him trying to shy away from this court appearance or the process itself, Your Honor.
He needed to go to community corrections.
I understand that, Your Honor.
He hasn't gone over it, hasn't done intake, hasn't done a test, done nothing.
Are you employed? Can you hear the court first of all?
Yeah, I heard him. He said I did nothing.
Yes, yes.
But I wasn't aware. I have asked about that and I never got a response. So,
Are you working right now?
yes, I am.
Full time
Yes, I am.
at the Dundee engine plant?
Correct.
Oh, yeah, sorry. Your Honor, my client is a lifelong member of this community. He is fighting these charges, and I do believe hopefully that he will prevail on these charges. He works, he has a wife, he has a household that he takes care of. He is truly, and again, if he's tested, he's gonna come back clean. He doesn't use drugs. He's not a drinker, so none of that is gonna be a problem in this case.
I don't know that.
I understand.
Because he didn't go over.
Your Honor, he can go right now and come back and report it to the court.
He wants to set for exam.
Yes, Your Honor.
Preliminary exam, the discovery is complete. Witnesses have will have their witnesses available on the 7th.
Yes, sir.
People, I meant to say. I'll set preliminary examination October 7, 2025, 9 a.m. As to his bond at this point, his bond is revoked. Maybe you can convince me of something else at some other point, but at this point, defendant's remanded.
Thank you, Your Honor. No, I'm sure.
Court calls case People versus Procopio Vitale.
You're on.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Vitale, who's making his way to the podium, Judge.
Oh, I have nothing. Go ahead.
Your Honor, there's
For an adjournment.
to state your name, Mr. Vitale.
Procopio Vitale.
Thank you.
Your Honor, there's a violation of probation in circuit court. I'm asking the court for a brief adjournment so I can see what's happening there. Also,
Is it set for a hearing?
It's set for October 2nd, Judge, with Judge Slay.
All right.
We're also trying to explore a recovery court.
Okay. So I'll adjourn this to October 9th, 2025, 9.
All right, and
Bond will continue.
thank you, Your Honor. Okay, if I give you.
Court calls case People versus Tanya. Is it Sheki? I probably messed that all up big time.
Victoria Burton Harris, appearing on behalf of the people, Your Honor.
And Assistant Public Defender Nicholas Bukovitz on behalf of Tanya Zarnicki.
Ma'am, can you unmute? And
We're trying to force it.
you're trying to force it. Okay. Got it. Can you state your name?
Tanya Lynn Zarnicki.
Okay. And I apologize about butchering your name. I have a nollie process where the people are dismissing.
No objection from the defense, Your Honor.
Case is dismissed.
Thank you.
On nollie process. Thank you.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
David I. Goldstein appearing on behalf of the defendant. May we approach briefly, Your Honor?
Yes.
Your Honor, briefly, we're asking for an adjournment till the 16th of October to have a we're working on a global resolution for all of his cases.
All right.
And
Go ahead. Record should reflect there's been a brief bench conference. I will adjourn the probable cause conference October 16th, 2025, 9 a.m.
Your Honor, the only thing that's holding him at the present time, he has two other cases pending, but he's on a personal bond on both of those cases. One is a Washtenaw County felony, one is a federal felony. None of his charges involve any allegations of violence. They all involve possession of weapons, but there's never been an indication that he has ever used these weapons. He has a he's a lifelong resident of this county. He has no other ties to any other community. He does not have a violent history. And therefore, we think $150,000 bond in this case is excessive. I know I made the same argument last week, but I'm making it again because we are working toward a resolution. I indicated something at the bench that I think the court would consider.
All right.
And I do think the court heard this argument last week and recalls the concerns that people expressed specifically related to text messages that the defendant was exchanging related to the sale of firearms.
Yes.
And the concerns that have surrounding that. I don't have any indication that I'm aware of that has engaged in violence in the past, but I think concerns about firearms. They were being possessed and potentially sold. I would ask the court to continue the bond as currently set.
All right.
I do understand that the 16th date was the date that Mr. Goldstein discussed with Mr. Panatra from my office, so that is a good date.
All right. So October 16th, 2025, 9 a.m. I considered this issue before. I'm giving you the same ruling. I don't see that anything's changed. It certainly has not in this court's mind. Motion for bond reduction is denied.
Thank you.
Bond will continue. Order. Court does call the case of the people versus Dominic for.
Trevor may vote for the people, Your Honor.
So finally, she's decided to do something today.
Good morning, Your Honor.
And she's just running around, getting in everybody's way, but it wasn't anything. Go ahead, I'm sorry.
Good morning, Your Honor. Ken Dadish on behalf of Mr. Brewer. Brewer, can you please state your name for the record?
Dominic Brewer. Thank you. Welcome back.
Thank you. You guys miss me?
You know, don't go far. I just said welcome back.
Right.
Alan missed you. I did.
Yeah, Alan.
I didn't even know you were gone. Go ahead.
You noticed though.
All right.
What's the notice? Thank you.
All right, what are we doing?
Here quickly, Your Honor.
Oh, there is a plea form. All right. The plea form indicates that the defendant is going to be pleading guilty to the charge of operating while intoxicated, second offense, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's accurate, Your Honor.
Yes, Your Honor.
All right, very good. May I have him sworn?
And do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth?
Yes, I do.
State your name.
Dominic Brewer. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. Yes, sir. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order any rehabilitative services the court deems necessary, as well as community service. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir? Yes, sir. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 1482 District Court. You understand that? Yes, sir. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty, Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes. Any questions regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Tether now. Okay. Well, it's not probation or. You're under the jurisdiction of any other court? No. Have you ever been to prison? No, sir. And you're not on probation or parole. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily?
That's when we get it in for. Yeah, but how am I gonna get out of here? Okay, I'll talk to you, please. I'm sorry, ma'am. This is 25G306623A, B, and C. Your name?
Here, let's wait.
You're charged with expired license and you have expired plate and no proof of insurance. Those are the three charges. One's a misdemeanor. You have the right to an attorney. Would you like a lawyer? So I'll go ahead and arraign you, explain the charge, possible penalties, go over your rights, and then I'll send you to the prosecutor, okay? It is alleged that on September 5 of 25 that you were operating a motor vehicle on Gibraltar Road near Meadow Lane in Gibraltar. Count one alleges no proof of insurance. That is a 0-point civil infraction. Count two alleges expired plate. That is a 0-point civil infraction. Count three is a misdemeanor. That is punishable. That's driving while license expired, punishable by up to $100 fines, 90 days jail costs, or all of those in 2 points. Do you understand that? Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
I did.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a hearing of the trial. Do you understand that? All right. You still wish to waive your right to a lawyer? Not guilty, please entered. $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand that?
Yeah, how do you have my business now in my?
Okay, you go tell the prosecutor that, okay? Thanks. Has everybody checked in with my court officer? If you haven't, come up and talk to him, please. Phillips, Donald Edward Phillips, 25T645-246A and B. Name? You're charged with leaving the scene of an accident and improper lane use, a civil infraction. Leave the scene as a 6-point violation. You have the right to an attorney. If you want one, I will give you. Would you like a lawyer?
No, sir.
So I'll go ahead and arraign you on August 31 of 25. It is alleged that you did operate a motor vehicle on Helen near Jefferson and Trenton at 1:25 in the morning. They think that count two, that you left the scene of an accident. That is a misdemeanor, punishable by up to $100 fines, 90 days jail costs, or all those 6 points would be added to your traffic record. You understand that?
Yes, sir.
And did you sign the advice of rights? To read it? Understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? You're also charged with improper lane use causing an accident. That's a civil infraction, 2-point violation. Do you understand that?
Yes, sir.
Okay. So do you still wish to waive your right to a lawyer?
Yes, sir.
I'm entering a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to send this to the Trenton prosecutor and you can go out in the hall and he will call you when he's ready for you. Either way, you're coming back in front of me today. Understand all that?
Yes, sir.
Okay, good enough. Thank you. If I did say set that for hearing, okay? If I didn't say set that for hearing, all right? Okay, thanks. Bye. People against Brewer, Janae Sue Brewer, 24WA35 430 25P645-360. Good morning, your name? You're charged with operating while intoxicated. You're also charged with the contempt issue. You owe $50 on file 430. You have the right to a lawyer. Would you like one?
Yeah.
Okay. I'm going to tell them to take this to the Trenton prosecutor and they'll set you up with a lawyer. Okay? Either way, you're coming back in front of me today. All right?
All right.
Okay? You can go have a seat in the hall. Anything else down there?
We have motion from yesterday.
Yes.
There's a sentencing ready. I told John to put it up.
Is it Lisa?
Zarnik.
Okay.
Got it. Thank you.
You're gonna move this, you're setting it for hearing. You need to find out when they're setting it for and getting those before, okay? Is Mr. Nelson here?
Zoom, he's coming in.
Elijah Michael Zarnik, 25T 644-864. Good morning, Mr. Nelson. Your appearance?
Good morning, Judge Rick Nelson on behalf of my client. He's present here with me. Read a Zoom.
Sir, your name?
State your name. Speak up. State your name. Elijah Zarnik.
All right, so your client pled guilty to the charge of operating while visibly impaired back on September the 4th. There's agreed upon cost of recovery of $225. It was referred for a screening and assessment. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
No addition, corrections, or deletions.
Okay, anything that you would like to say on his behalf?
Your Honor, comes from a good family. He's here present with his mother, who's been in all the court proceedings. This was a very low breath, 0.81, I believe it was. Graduated high school recently. He's working full-time at Henry Ford Wyandotte Hospital. He's on the right road. This is an aberration. I just ask you to take in consideration he's working 40 hours a week and maybe limit some of the community service or court work program hours.
Sir, anything you would like to say?
No, Your Honor.
All right, you know, the only thing that concerns me, I think I expressed this before, you don't have the ability to drink and you're out. I mean, they had reports, I looked at the police report today that somebody was driving in the ditches is the way they said a white Chevy Trax that was driving all over the road and went into a few ditches. You gotta be really careful here. I mean, I'm more concerned for you than I am anything. I mean, you just can't do this. This can affect your future. You just can't do this again. You understand what I'm telling you, son?
Yes, Your Honor.
13 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs. I'm going to make that as follows. Bi-weekly for 3 months. If you're clean, I'll make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. You're to attend an outpatient treatment program. I probably should require you to go to AA until you're in it, but I'm not. But I want you in there no later than November 1. So you should sign up today. Do you understand what I'm telling you?
Yes, Your Honor.
All right. 4 days jail, credit 1, serve 3. I'll let you serve those on our court work program. There's a $35 a day charge for that for a total of $105. All right. So 3 days court work program, outpatient treatment, victims impact, chemical testing as I outlined, $300 in fines, $225 costs, $75 victims' rights fee, $50 justice assessment. So your fines and costs are $650. Your probation fees are $260 for a total of $910. Screening fees $60 for $970. You have cost of recovery of $225, bringing your total to $1,195 plus the court work program fees. Everything included is $1,300. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Also, I want you to understand, if you're compliant and there's no violations and you've completed all the programs in half the time, 6.5 months, you can come in here and request early discharge, but you can't have violations within the preceding 90 days. So do you understand everything I've said, Mr. Zarnick?
Yes, Your Honor.
All right, you seem like a really nice kid. Don't do this to yourself again. Can he pay all this today or does he need time, Mr. Nelson?
Need time? He needs time, Your Honor. He is working.
Okay, how much can you pay today?
500.
500, Your Honor.
All right, you come here and pay $500 by 1 p.m. We'll put the file and then you're gonna meet with probation. They should be able to meet with you today, okay? And then that'll save you a trip. And then I'm gonna just let you pay what you can outline your payment plan. Can you then pay $50 a week?
Yes, Your Honor.
$500 by 1 p.m., $50 weekly. I'll start that beginning on October the 3rd, let's make it the 17th, okay? If you ever need more time because something happened, you call the court, we'll go on Zoom. I'll be glad to give you an extension. I don't care how many times we have to do it. And if you want to come to court instead of going on Zoom, you just come up here, all right?
Thank you, Judge.
Thank
Or
you.
before the due date, 8:30. Thank you, Mr. Nelson. Have a good
Welcome.
day. Good
Appreciate you too.
luck, young man. Good luck. Thanks.
Do you want yesterday's?
Yeah. Witherell. Corey Daniel Witherell. 25B148939. A. B. A and B. Defendant failed to appear yesterday for a show cause on file A, warrant to issue 3,010%. On file B, 3,010%. Defendant having failed to appear twice now. People against Ashley Michelle Turner, 25B148977. Defendant failed to appear yesterday for a show cause. Warrant to issue, bond to be forfeited 3,010%. Pamela Sherry Simpson, 25B149063. Defendant neglected to show up. Warrant to issue, bond to be forfeited. Again, for failure to appear for show cause, 3,010%. Robert Hardwick Smith Jr., 25B149115. Warrant to issue, bond to be forfeited 3,010%. People against Matthew Shane Atkinson, 25B146314. A and B, defendant failed to appear for a show cause yesterday. Warrants to issue on each of these 3,010%. On each of these. Was that a phone or something? What went off back there?
You guys got a phone, you gotta turn it off, take it out.
What went off back there? Somebody needs to tell me, please.
When my client's phone go off.
Come on, guys, listen to me. I heard it from over here. Just tell me. Nobody's gonna be in trouble unless I gotta keep doing this.
Turn your phones off, get them out of the.
What was that, sir?
Mike, no, it was my phone.
Was it yours in the back?
What's outside of this?
Well, we both heard it. I don't just hear things, okay? This isn't a haunted house.
That's hilarious.
Paul Morrison, Paul Ricardo Morrison Jr., 2R512692. Defendant failed to appear. However, he posted bond, didn't he, Lisa?
Name?
I mean, it looks like Warren canceled, posted on September.
What's his last name?
Morrison. This was
First
up
name?
yesterday, 22R512692. It looks like they posted, but I don't have any bond receipt in the file.
What's his first name?
Paul Ricardo Morrison Jr.
Yeah, it does say that he posted, but we didn't receive the bond yet.
Where did he post at?
I don't know. I'd have to look back at that.
I mean, they posted a bond on,
That's what the note says. He's got multiple cases though, so maybe he posted on the other one.
okay, I'm gonna put this aside. Can you check on that? I don't want to issue a warrant. If he's posted, I'll apply the bond, but there's nothing. Are they still putting the bond receipts in these civil infraction files, I hope?
We didn't receive a bond.
Yeah, okay, I get it, but okay. I don't even see how he could have, I mean, I guess he could have posted 2/13 on that date. But this is 20 days. I mean, I'd like to know what agency is holding on to bonds for 3 weeks. So anyway, check on that, please. And don't let me forget about it, if you would. People against Scott Luke Tech at 25B149006A B and 19I714701. Okay, so defendant failed to appear for show causes. 3,500, 10% on the A file. B file. 3,500, 10%. And 19714701. 3,500, 10%. Schedule this for 9:15. Is that when it was scheduled? It looks, oh, yesterday, yeah. Okay. Nazir A. Chowdhury, 25B826-4A. And B. We're going to issue show causes. Defendant failed to appear on these. His name sounds familiar. I don't know if he had another one in front of me. I also have a C file. Same thing there. I'm issuing the show cause. For failure to appear. Caitlin Nicole Wojciechowski, 25B149443. Defendant neglected to show. Issue show cause. You have anything else down there? Yeah. Hand it to me. I'll read it. Linda K. Rainville, 25T646325. Camilleri. Good morning. Your name? Can you hear me?
Judge, are you talking to John?
I am. Your appearance?
Attorney John Camilleri on behalf of Linda Rainville.
All right, so this is, you've met with the prosecutor, you're going to plead the impeding, and that's right, correct?
That's correct, Judge.
All right, and you're authorized to enter that plea on behalf of the defendant?
I am, Your Honor.
All right, to that charge of impeding, responsible or not responsible?
Responsible.
Accept the plea, dismiss the original charge, 160. Can they pay that today, or you want a week?
I'm gonna mail a check in right today, Judge.
I'll make
got
it
it in my
October
hand.
1. Oh, okay, great. October 1, thank you.
Thank you, Judge.
Norbert Pastor, file 25T644584. Could I have Jameson seated at the table here, my right, your left, please? Good morning, Mr. Zellner.
Morning, Your Honor. James Von Gravis here. Step up, Mr. Pastor. Edward Zelenak for the defendant will waive the reading as court to stand mute.
Sir, your name?
My name is Ward.
All right, so does he have any priors, Mr. Zellnick?
About 5 years ago, since, yeah, about 5 to 6 years.
All right, not guilty, please enter $1,000 personal bond.
No terms including no drink, no drugs.
Yeah, here's what I'm gonna do. Sir, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you going to AA, NA at least twice a week. And you don't have to have, and there's to be no contact with prosecution witnesses except through your lawyer. You do understand if you're convicted here, you're going to lose your license. It's going to be revoked, right?
Understood.
Okay.
I already sent him for a substitute.
Okay, so we're gonna hand him an AA form. You have to go in person, and every time you go, you have to bring the form with you and have it signed, and every time you come to court, you have to bring it with you. You understand that, sir?
Yes, sir.
Okay. What do you have, Lisa, for a pretrial?
October 9th at 9 o'clock.
Is that good with you?
I'll check if there's a problem, I'll report it. No, that is a problem. So I know that Mr. Bologna won't be here that day. He's gonna have an assistant.
You want to do it the 23rd then? Is that my next date with them?
23rd at 8:30.
October 23rd at 8:30, okay?
Thank you, Judge.
All right, sir, you can go down the hall and they'll give you a notice. So put that date in your calendar, give them an AA verification sheet. So you'll go down the hall and get your notice and we'll see you back here. Any questions?
No question. Maybe one question you have. I have a European trip scheduled to see family. Is it a problem? Say go in the state.
Well, they need permission from the court.
When is he going?
Was planned for the end of October.
Have you already booked your tickets?
Not just yet.
Do you know what date?
Not yet specific.
All right, so
You're going hungry or where are you going?
I'm not gonna have a problem. I just don't want to tell somebody you can go to Europe when you're got a case pending and I don't even know what's going on with.
Judge, I'll get the information for you.
No, I have no problem with him leaving the state. Let me just finish my thought here. I don't have any problem whatsoever with him leaving the state. What I do have a problem with is telling somebody you can do. And then for some reason goes to Hungary or wherever and they detain him because they got a case on lien. So that's something you're gonna have to check with. I don't think it's a problem. Like Canada is an example. You get a drunk driving in the United States, you're not going to Canada. So that's the problem. I don't know what, and he's got one on his record. So I'll let him leave the state. You can tell me the dates when he comes back, but you got to double check. That's all.
Certainly will.
Okay.
That's the Victor Orban government, which is fueled by Slivovic and Malenko. So I'm sure they'll have no trouble getting in. Getting out might be a problem, but they'll have no trouble letting you in. Judge.
All right.
Step outside, go down to the counter, say, wait for me to get your paperwork. Judge, I appreciate your accommodation. We'll bring you the travel information. He owns several medical clinics here. I don't think he's gonna either not appear. Or
I'm not worried about that. I'm worried about him getting detained. That's all. So, you know, and I'm not saying it's going to happen. It probably isn't, but I don't know what countries are doing that, what countries aren't, and I'm not going to be responsible when somebody says, hey, you said I could go to wherever, whatever country, and I ended up there for 9 months. Anyway, that's it. Nehemiah James Jameson, Nehemiah James Jameson, 25G82767.
We're selling that for the defendants, Jameson step up. Judge, he apologized. He owns and works for a towing company. He was working this morning. Otherwise, we'd address properly for court.
What's that?
My apologies.
You're all right. You're fine. State your name.
Nehemiah Jameson.
So what happened here? Did they take care of everything?
No, he's waiting for the probate money to be released. They asked to dismiss it. He's supposed to go pull permits with a contractor. And if not, he's gonna be right back here. And
Just make sure you take care of this. They're not gonna forget about you. Okay?
Could we have before he walks out of here, just a 10-second advice him like we do as the judge? This is sometimes you undertake things because he inherited the house and it's tied up, the money's tied up in probate. Sometimes there are things you have to walk away from. This house was constructed 30 years ago. It's like a Frank Lloyd Wright house inside. And there may be things, sir, that I can't tell you because I'm not a relative. The judge can tell you that you can't control, and it might be time to sell and move on. You don't live there. You understand that, right? You may have to make a family decision that's in your best interest. You're running a big towing company. Do you understand? No, that means yes, Judge.
Do you understand?
Yes, Your Honor.
I mean, we fall in love with things, Judge, but certain things we
You're
have.
saying unfinished construction home after 20 plus years, countless warnings. It says 20 on the ticket.
Died, he signed over the house before he died, and his administrative estate hasn't got the money released yet for construction. Sometimes there are things you move on with, Judge.
I get it. Young man, good luck to you.
It's like when you tow those cars on the freeway, you gotta be moved. Thank you, Judge.
No problem. You got Jim Construction too, Mr. Zelnick?
Yes, I can step outside. Well, your mother, I want you to come up with her. She doesn't speak. She speaks nothing that's understandable.
So what do I have here? I've got 3 files. Jim Construction Services, Inc., 25T645896 A, B, and C. We got the whole family here, eh?
Well, you're missing the third. We got M and we got Y, but G is outpouring contract or something.
All right.
Now, Your Honor, give your name, ma'am.
Maria
Garcia is the president of the company. Is that correct?
Yes.
You know enough English to understand what's going on here. You're a U.S. citizen. Is that correct? Resident. And you are the president of the company because your two boys made you president. Is that right? Yes. And you didn't show up for a ticket that you got here, the name of your company, because the foreman and your sons didn't tell you that to be. Is that correct? All right, and we're ready to resolve that.
All right, so I've got a stip form that says they're going to dismiss the spill load and she's going to plead to, or the company's going to plead to defective equipment count 2 and improper display of plate, right?
You understand that? You're being responsible for it, right?
Do you understand everything, ma'am?
Yeah.
What color's my robe here?
Oh, no, we got somebody whispering in Spanish. Yeah.
Ma'am, I just want to make sure you understand everything. Mr. Zelnick, I can actually do this through you since it's civil. Are you authorized to enter these pleas on behalf of the company?
Yes.
All right, to the charge of defective equipment, responsible or not responsible?
Responsible, Your Honor.
And on the charge of improper display of plate, responsible or not responsible?
Responsible. There's a further separate agreement placed on the record with the city of Trent that there was dripping water that had concrete particles in it onto the street. And if there's any cleanup costs, your company will pay that. You understand that? Mrs. Garcia, you understand that, is that correct? All right.
And he understands, the prosecutor, of course, that I have no authority to order that in the civil.
No, Judge, they're good business people.
I get it, okay. Fines and costs on each case of 210 on the 2 files. I'm dismissing file A. Can they pay the 420 today?
Yes.
All right. Good luck to you, Maria. Have a good day. Take care. Thank you. Good to see you, Mr. Sen.
Waiting, I just wanted to pass on that I ran into Judge Galicki and he asked you to call up and set that arrangement again.
Yeah.
Call me anyway.
All right. Take care. Thanks. Good to see you. All right. What else do I have? Is Tyler Mull in here? You're Tyler Mull. Where's the defendant on Tyler Mull? Do we have Eldridge here? Chelsea Eldridge?
She is not checked in with me, Your Honor.
Yeah.
Okay, so why is this
Oh,
break,
sorry. I think it's somebody else.
why is this breaking down like this? Are they telling everybody to check in?
No, she's checked out by Eldridge. Eldridge is here.
Terrence Arnold Hall, 25T646123. Where's Mason Gate? I don't have Mr. Gate. Sir, have a seat at the table behind you, please.
Pardon me?
Have a seat right there at the table, please. No.
Right here.
Right here at the table.
Okay.
Amani Antonia Segenza Bryant, 25G306334A. If you can call Mr. Gate. Who's handling Chelsea? Yeah, he's on both of those. Tell him I want to do Hall and Eldridge. Where is Amani Seguenza Bryant? Come on up here. 25G306334A.
Is it Burnett as well?
No, that's my old.
Seguenza Bryant. Okay, that's all right. Your name?
Marnie.
You got a charge of failure to pay $483. If you plead guilty, if you're found guilty, you could get 60 days. Do you understand that? I can't hear you.
Yes, I did.
Did you sign the advice of rights? Did you read it? Understand it? If you plead guilty, you will be giving up all those rights and there will not be a hearing. Do you understand?
Kirby, Ms. Tranter, on behalf of the state of Ohio, we're here for sentencing. Has everyone had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
Yes, Your Honor.
Ms. Tranter, anything on behalf of the state?
Nothing further.
Anything from probation?
No, Your Honor.
Mr. Kirby?
Judge Michael just turned 47. The date of this offense was back in August of last year. He voluntarily engaged in full circle. He's in recovery. Things are going well for him. I believe that community control would adequately punish Mr. Chapin. I don't think it would demean the seriousness of the offense. We ask the court to place Mr. Chapin on community control sanction. That's all, Judge.
Mr. Chapin, is there anything you'd like to say, sir?
No, sir.
All right, the court has considered the pre-sentence investigation, the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to find that you are amenable to community control. Mr. Chapin, I'm going to place you in community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs or alcohol, and this includes marijuana or THC in any form. You're ordered to complete the treatment as you started at Full Circle. You're ordered to complete the thinking for a change course. You are to have no contact with your co-defendant. And once you get to the point, I ultimately wanted to see you get full-time verifiable employment. You had 0 days jail time credit. Now, I noticed that, what's your plan after Full Circle?
Get a job, get me a place to live, get outside of Middletown.
Okay, I was going to say, you need to move out of Middletown, at least into a different neighborhood. You cannot stay in the same environment that you've been living in, because by your own admission, everyone knows you there as a drug dealer, and it's just you're going to be sucked right back into that lifestyle. So if you're serious about making a change, find somewhere else. There's plenty of places to live somewhere else, right? You agree?
Yeah, I agree.
All right. The court at this time is going to find that he's indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to a discretionary period of post-release control, which means if you are sent to prison on these charges upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me?
No, sir.
All right, I need you to head down to court services. You're going to test today, and then you're going to meet with your probation officer, and good luck to you.
Okay, thank you.
Thank you, Judge. I recognize this as Pam.
All right, this is case number 25CR42346, State of Ohio versus Damian Dennis. Mr. Dennis is before the court with his counsel, Mr. Lewis. Ms. Tranter is here on behalf of the State of Ohio. This is our final pretrial before our scheduled commencement of the jury trial, October 23rd, 2025. Ms. Tranter, anything on behalf of the state?
Your Honor, the only thing that I have today is I would like to place the final plea offer on the record. I'm doing some math, and it looks like by my calculations, the maximum term in the indictment, if the defendant is found guilty as charged, would be 34.5 years in the Department of Corrections, with a mandatory term of at least 14 years, minimum mandatory term of 14 years. The state's offer is to present a potential plea to count 1 of the indictment, which is, well, basically all counts of the indictment except for the possession, with an agreed recommended sentence to the court of 16 years in the Department of Corrections.
All right, Mr. Lewis, Mr. Dennis is rejecting that offer.
He is, Your Honor.
Okay. All right, Mr. Dennis, you understand, I'm sure Mr. Lewis is a skilled trial attorney. He's explained to you the the potential consequences of going to trial, which again, I don't typically have a trial penalty, but obviously there's a lot more at stake when you decide to reject an offer where there's a recommended sentence. You understand that? Is that correct, sir?
Yes.
Okay, no problem. You're required to be here at 8 o'clock on October 23rd. I would caution you not to dress that way. I don't appreciate someone wearing shorts into my courtroom. Again, I don't know what your situation is, but I'm sure Mr. Lewis, he's sitting there with a nice coat and tie on. Ms. Tranter's dressed up. I just don't appreciate you wearing shorts in the courtroom. Do you have long pants?
Yes, I was under the impression that I wasn't coming in the courtroom.
Okay, fair enough. Fair enough. I'm not going to lose my mind over it, but just when you come back for the trial, just please dress appropriately. Okay, sir?
Yeah.
Anything else that Ms. Tranter?
No, Your Honor.
Mr. Lewis?
Nothing, Judge, other than, forgive me for sitting, again, this is up to Ms. Tranter and I will continue to have discussions with the state and keep the court apprised of our progress.
Okay, very good. And we'll look to get started on the 23rd at about 8:30 to 8:45. Okay?
Thank you, Judge.
All right, thank you.
Thank you, Amy.
Let's talk before you leave. Because I'm.
Understand that. You have the right to an attorney. I'll be happy to appoint you one at public expense if you want one. Would you like a lawyer? I can't hear you, ma'am.
No, sir.
To the charge that you failed to pay $483, how do you plead?
Yes.
Did you fail to pay?
Yes.
Anybody forced you to plead guilty?
No.
Please accept it. Why didn't you come and talk to me? I don't understand. Hang on a second. It's one of the most frustrating things. I almost let people determine how much they're going to pay. And then I tell them, if you don't have the money, come talk to me, but don't ignore me. And you didn't pay, and you didn't talk to me, and you ignored me. Why would you do such a thing? I don't get it. I don't understand it. Why weren't you in here with your money? And why didn't you come and take advantage of my nice offer to come talk to me on or before due date if you didn't have them? I don't understand it. That's one of the things I'll have to devote a chapter to in my book, because I just don't get it. I really don't. Why didn't you talk to me?
Well, I did call
Call who?
up here.
I don't get on the phone with people. I never said I'd get on the phone with you. And what did they tell you?
Well, when I was here last, you said.
You were here on April 24th.
You said if I cannot make the payment, call up here.
Call up here and go on Zoom with me, or come in on or before the due date in person. That's what I told you. That's exactly right. I didn't say call and talk to a staff member and tell them, hey, I can't make the payment. Is that what you're trying to tell me you did?
No, I called and I asked for a court date because of the fact that.
You didn't need a court date. You needed to come in here on or before May 30.
Well, I wasn't able to come up here at the time.
Why? You live in Rockwood, right?
I understand, but
How far is Rockwood from here? How far is your house from?
probably maybe 10 minutes. But I have,
Do you work?
No, I don't. I've just literally just started working on Monday.
Where?
I work at BTW for FedEx. I'm an admin.
Who do you live with?
It's just me and my son.
You gotta come talk to me. You gotta come talk to me. Come on. If I told you I was gonna give you $3,000 if you came here that day, you'd have figured out a way to get here. If you told me this is not yours.
This is mine.
I know, but this lady isn't, right?
Yes.
Yes, I spoke.
I didn't even know we gave the lawyer. Okay, I see waived on the file.
That's already written in for point on the document.
I'm sorry then, I didn't know. I mean, I don't know how she got to you. How'd you happen to talk to this lawyer?
It was on the document.
It's her assigned attorney previously
Yeah,
when
but
she
that
took
was
her
back-
plea.
That was back before the adjudication, so.
I understand all the 840s are time to pays.
At any rate, go ahead, Mr. Gates. What do you want to say? I'm not excited about the fact that she didn't bother to come and talk to me. I'm telling you, I don't get this.
I understand.
Your
I did not know that.
your appearance,
Little Miami school districts. There is not currently a immediate need for that, but we definitely foresee that with her having her children in Little Miami school districts, and the victim also having the children in Little Miami school district. We're just asking for a modification as it relates to school property that would not be a violation of the no contact order. And I would submit for the court that there was also a domestic relations civil protection order that was going on simultaneously to this case. That case was dismissed, I believe, officially last week for the petitioner, the victim in our case here, failing to appear. However, prior to that, there was a magistrate's order in which there was a permission, and the exact verbiage here is Ms. Taylor may attend graduation and other school events with Little Miami High School without violating the order. I do have a copy of that if the court would like to take.
I would like to see it.
It's just-
No, I haven't seen it.
Okay. I'm sorry, this will not let me open up my notes. Stupid computer system. Just do me a favor.
Yes.
This, I don't know why it won't let me open up the Dropbox. Let me try one more time. I just go in and it should be open to the criminal notes and print out Kelsey Taylor's notes for me, please. What does the no contact order what does it currently say?
I believe it's just a part of her conditions that she can't have any contact with Mr. Scott.
And Your Honor, because of the vagueness in that language, that's the reason that I wanted to get an official ruling, knowing that, yes, she cannot have any contact. We're not asking for her to have any contact. But when we have a situation where we know two people will likely.
Did we have this discussion recently, or was that a different case? I can't pull up my notes, so I can't go back.
I think that was on a different case, Judge, but we had a similar discussion, I think, on a different case.
Has Mr. Scott been notified of?
Yes, absolutely, Judge. Ms. Burrell's been in contact with him. He,
I guess they have children together?
No. They do not have children together. So Mr. Scott has his own children in the district. Apparently Ms. Taylor does as well.
Is that right?
Correct.
Okay.
So Mr. Scott has been spoken to. He doesn't have an objection to her attending events as long as the court makes it clear that she's to have no contact with him or his children. Because I think there have been times in the past where there has been at least alleged contact between the defendant and his kids as well.
Thank you.
So as long as that is made clear, he doesn't have an objection.
All right. I mean, folks, at some point in time, common sense has to prevail in these situations. What grades are your kids in?
My daughter is graduated, Your Honor, but my son is in 8th grade.
So you have an 8th grader.
Correct.
And Mr. Scott has children at what grades?
His son is graduated. His daughter is in 11th grade. So next year, my son and his daughter will be attending the high school together.
Okay. All right. I don't, is there any issues on supervision?
No.
I don't have any problem. I mean, again, the order doesn't prohibit you from attending events at Little Miami. And I don't have any problem with you attending any of your child's events at Little Miami.
Thank you.
That's not the purpose of the order. It never was. Obviously, if Mr. Scott is at the event, I would say go to the other end of the stadium, go to the opposite side of the baseball field, sit on the opposite side of the basketball court. Do not approach him. Do not have any discussions with him. Do not approach his child or have any discussions with his child. Don't allow anyone to do so on your behalf. I mean, to me, it's common sense, but I understand why you're being cautious. So, the order is modified as such that there's certainly was never intended to keep you from attending your child's activity.
I understand, Your Honor.
All right. Am I covering it, Mr.
Absolutely.
Okay.
Absolutely.
Is there anything else then that needs to be modified?
Nothing further.
Okay, so basically this will reflect the same as the court's order in the domestic relations court. You can attend those events without violating this court's order as well. Okay,
Thank you,
you want this back?
Yes.
All right, anything else, folks?
No.
All right, very good. Thank you all.
Thank you.
Thank you. All right, this is case number 2007. Is that right? 07 CR 24533, the state of Ohio versus Donnell Cole. I have here a signed nollie from Chief Assistant Prosecutor Mr. Knippen. The defendant has died as of December 24th, 2023. It was found by court services. Anything else, Ms. Tranter?
No, Your Honor.
All right, the court will grant the nollie at this time, and that case is over. Thank you.
Judge, I did speak to Ms. Bryant and I did let her know that the court's made her aware at the time of sentencing, if she needed additional time to call. She did tell me that she did call, but whoever she spoke to told her to go ahead and just wait for some paperwork and then come into the court.
They would never tell them.
That's exactly what was told.
Wait for paperwork, wait for a show cause, you call, hang on. You're telling me you called on or before May the 3rd, and they told you to wait for paperwork, in other words, a show cause contempt hearing? If I knew who told you that, I would go down there, union or no union, and fire them right now. So if you know who it is, tell me.
I don't know the words. Or whoever.
They would never tell you that. They would never tell you that. Wait for the paperwork so that you can have a show cause filed against you. She doesn't have the money, right?
Money today, Judge, and then she just started a new job this week. She will need just a little additional time to pay the balance, but she does have, she said she's able to pay half of what is owed.
She's only gonna have to pay $200 today. And then I'm gonna let her set up her new payment plan. And then next time, so there's no confusion, I didn't mean to call and tell them you can't pay and get advice from them. They're not judges. Okay, I meant for you to call. I need to go on Zoom with Judge McNally to talk about time to pay, or you can come in here on or before your due date, in person at 8:30 in the morning. So all these time to pays are gonna be at 8:30 in the morning. All right, you take 200 a day. How much can you afford to pay weekly or bi-weekly?
I can finish the payment next Friday.
I don't need you to fix you. How are you eating if you haven't worked in 4 months and you got a son and you just started working? Is that not what you told me?
I literally started working with for my first check, they get paid bi-weekly. So with me working this week, I get paid next Friday.
You're still gonna owe $283. You don't need to pay all that now. It's not my intent to make somebody not eat. it's my intent to show people to, or at least try to convey to people, you need to have the slightest amount of respect. I can let her pay 50 a week, 40 a week, whatever you want, Mr. Gaith. I'm gonna make it $50 per week, but you can pay it. But you can pay it,
She's able to do $50 a week, Judge.
and I'll start it October the 13th. I'm sorry, October the 17th. That's okay. If you need more time, you're gonna come talk to me, right?
Yes.
If you want to pay more, you can, but all right, good luck. Terrence Arnold Hall, 25T646-123. You're welcome.
Good morning, Judge. Madison Gates, apparent back of
Mr. Hall, come on up here and state your name.
Judge, Mr. Hall is a little bit hard of hearing.
Okay, I'm sorry. Your name, sir? Your name?
Terrence Arnold.
All right, so as I understand it, he's going to plead guilty to no valid ops, the suspend to be dismissed, right?
Correct.
Is that what you want to do?
Yes.
If you do that, the possible penalties are up to $100 fines, 90 days jail costs, or all those. Do you understand that?
Yes.
Did you sign an advice of rights form here today?
Yes.
Did you read it and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge, no valid operator's license on person. How do you plead?
How do you plead to the no valid license on person?
Okay.
Were you operating a motor vehicle on West Jefferson near King and Trenton, August 7 of 25 at 8:59 in the morning? Yes?
Yes, yes.
Did you have a valid license with you on your person?
Yes.
I can't hear you.
Yes, sir.
You had a valid license on your person that day?
No, sir. No.
You're not even licensed. You're not even licensed, are you?
No.
Why are you driving?
Working.
You can't drive without a license.
Yes.
How old are you?
65.
Did you ever get a license?
I'm trying to get them now.
You've never had a license before?
Have you ever had a license?
Oh, yes.
When?
Back in 2011.
I don't know what to say. Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
You can't drive without a license, sir.
Yeah.
Plea is accepted to no ops. The suspend is dismissed. Anything you'd like to say on sentencing, counsel?
Just that I've explained Mr. Hall the procedure to go ahead and get a license. And he's gonna go ahead and work on that in the interim and then hopefully this won't happen again. Is that correct, sir?
Where does he work at?
Myers.
All right. Anything else you want to tell me?
You want to say anything to the judge, Mr. Hall?
Yes.
Go ahead.
Well, I used to work with Amazon. I was terminated from there in May. Yeah, and I just started working at
Okay, $100 fines, $175 costs. I have to charge a $75 victim's rights fee, $50 justice assessment, 40 in attorney fees, 440 or 90 days.
Do you have that stated date, sir?
Could pay next week.
All of it, or you want a payment plan?
Yes.
You want a payment plan?
Yes, sir.
How much can you afford to pay? How much can you afford to pay? It was $440.
100 a week.
I'll make it 75.
Thank you.
75 per week, beginning on, I'll give you some leeway time, October 17th. If you need more time to pay, no problem. Call the court. We'll go on Zoom on or before any due date. And I'll be glad to give you an extension, okay? Or you can walk in here on or before any due date that you don't have the money. Good luck. Any questions?
No, sir.
All right, good luck. Thanks.
Thank you.
Chelsea Leanne Eldridge, 25T645-759 A and B.
Good morning, Judge. I'm happy to hear that. So,
Ma'am, your name?
Chelsea Leanne Aldridge.
Mr. Mull, come on up here, please. This defendant is seeking restitution. Defendant pled guilty to allowing an unlicensed driver to drive, and she also pled responsible to failure to yield. Go right over to that microphone. You don't have to go in there.
Come on.
Come on out.
Right
Right there.
there.
Your name?
I don't know.
Thank you. He's seeking restitution. Your client pled guilty to allowing unlicensed driver to drive. She also pled the failure to yield. You did a great job getting the leaving the scene of a property damage accident suspend charges dismissed. Did you have a chance to review the victim statement?
We have, Judge, and I did advise Ms. Eldridge that there may be restitution owed in this case.
Was this covered in any way by insurance? What would you like to say?
Judge, just that Ms. Eldridge, since the time of the accident, has taken steps to get a valid license. She currently does have a valid license. And it was not her intention to leave the scene at the time. It was just the way that.
God picked her up and flew her car away?
No, Judge, she was intended to go around the block because there was an issue with parking. She was right across from where she actually worked. And by the time she had made it down the street and coming back on the way, she was stopped by the officers. But she did advise me that it was not her intent to leave, Judge, but she does understand that she should not have left, should have stayed there until the officers arrived.
Anything you'd like to say?
No.
So he's got two bills here. Right? Well, how much is your total here, young man? You got $399.73.
Those are just different estimates.
Here's what I'm doing. How old's your car?
It's a 2011.
I'm not gonna give you this until you get it fixed. Okay? So, I mean, I don't want people collecting money based on estimates and then not getting it fixed or going to their insurance company and essentially double dipping. So I'm simply going to fine her. You go get the car fixed if that's what you choose to do. If you choose to choose not to go through your insurance. And I'm going to set a restitution hearing on this. Okay? So I'm going to put this out. I'm going to sentence her now, counsel.
Okay.
And I'm going to order her to pay restitution as ordered following a hearing. Anything that you would like to say, you want me to consider, sir, before I sentence her?
I'd just like to say it was not my awareness that she was going around the block. It was my understanding that she was just going to the parking lot next door. I was going to call the police either way.
And then what'd she do?
So I was in the spot and it was on the parking lot. I understood that she was going next door. I don't know why she even needed to go next door. She said
You don't think I bought that, do you? You don't think I bought that, do you? I've been doing this since I was a kid, practically. I don't buy that.
That building she went across the street to was actually where her phone ran out of batteries. She had gone to make a phone call at that point.
You don't have a cell phone?
It ran out of batteries.
Yeah, it was that. And I went over.
Why did you need to make a phone? Why did you need to make? Let's not make this worse than it is, okay?
To let my fiance know that.
That wasn't your obligation. Your fiance is not the police. You needed to call.
Told me he was called to the police. That's why.
How long did you wait there?
I immediately called the police.
And then the police showed up how long after? And was she back yet?
No, but the police showed up and they.
Wait, don't interrupt them. Say again.
When they arrived, they informed me that they already stopped her.
All right. Anything else anybody wants to say?
Nothing else.
On the allowing unlicensed, and you don't want to say anything else, right?
No, Your Honor.
On the allowing unlicensed driver to drive, 100 fines, 150 costs, 75 victim's rights fee, $50 justice assessment, 40 in attorney fees, plus you're going to pay restitution as ordered following a hearing. I'm going to set a hearing on restitution. You owe 195 on the failure to yield. So your total here amounts to 610, and then you're going to have to pay restitution, which, do you know what the total amount was?
The estimate was 300, the lowest, and the highest was like almost 500.
All right, let's set a restitution hearing in 4 weeks. That'll get you you'll be able to save some money, okay? Set for October, whatever, Lisa.
October 23rd, 8:30.
At 8:30, all right? Now, can she pay this money or does she need time?
She'll need a pen.
Does she have anything?
Yeah.
Where does she work at?
Work at Success on the Spectrum.
She works with autistic children.
All right, I'll tell you what, can you pay $50 per week?
Can we do 40?
$40 per week. I'll start it beginning October the 10th, okay? Now, if you need more time, I don't have a problem if you don't have the money. You got to call the court. We'll go on Zoom before the due date at 8:30, or come in here and see me, okay?
Okay, Your Honor.
So $40 a week, we'll have you pay on the B file first, and then you're gonna pay 40 per week after fines costs paid on B. That's on the A file, you'll pay that secondly, and then we're gonna have the restitution hearing October 23 at 8:30. So you can go down the hall, get your notice. I want you to get that notice too, and then you bring me proof that you've either that you've had it fixed or that you've taken it to the insurance carrier. You take it to your insurance carrier, technically they're allowed to subrogate and actually go after her for the other money. They probably wouldn't over $500 or $300, but they do have that right, okay? All right, any questions, sir? Ma'am, any other questions?
Getting out of budget.
No, Your Honor.
All right, best of luck to you. Thank you. Daniel Van Kusick, 25T646-368. A and B and C. All right, Mr. Kusick, come on up to the podium. Tell me your name.
Daniel Van Kusick.
You're charged with open intoxicant, possession, of drug paraphernalia, and detective equipment. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
Yeah, I guess.
Okay. We'll give you a lawyer. Sir, in the front row, what's your name? Go out in the hallway, Mr. Kusick, and I'm gonna have them bring the file out, okay?
Okay.
Sir, what's your name? What are you?
Speeding ticket, to last week.
All right. Come on up here, Brian Thomas Davis, 25F244508. Lisa, we don't have a officer here. This should be Officer Hunter from Flat Rock.
Never checking them.
Not on Zoom.
Your name, sir?
Brian Davis.
All right, we gave him 15 minutes. It's 9:50. Case dismissed, okay?
Thank you.
You're all set. I wish you well. Good luck. You too. Cherie Nicole Bowman, 25W839397. Officer Perry here, Lisa.
He doesn't check on me.
Not on Zoom.
Your name?
Sure, Nicole Bowman.
Case dismissed. I gave them 15 minutes. You're all set. I wish you well. Good luck. Yeah, I hope you have insurance though.
I brought it.
All right, good. All right, Ariel Swayze, Ariel Siobhan Swayze, 25G306-623A, B, and C. Your name, ma'am? All right, so you negotiated like a hotshot lawyer here. You're gonna plead to expired plate
Yeah.
and no insurance, right? And they're gonna dismiss, the driver license expired, right?
Yes.
All right, so you understand that no insurance, expired plate, or civil infraction. There's 0 pointers. You understand that? To the charge of no proof of insurance, responsible or not responsible? To the charge expired plate, responsible or not responsible? Do you have valid registration and insurance now? Tell me you do. You have them with you?
Yeah.
Let me see. You can hand that right to my recorder, right here. Okay. How long was your insurance expired? Since June of 25, so it was expired for 3 months. You know what you never want to do is to go without insurance, getting involved in an accident. They'll chase you around like you can't believe. This is just your note, your insurance. Did you go over to the Secretary of State? Today at 2:30, I'll trust you'll take care of that, okay? All right, I'm gonna charge you on the no insurance since you brought in proof, 145, and on the expired plate, which was expired since June 11th as well, I'll make it 125. So you owe 270. I'm gonna hand you back your insurance. Can you pay that now? And I'm dismissing the expired license. Where do you work?
Stay at home right now, I'm just having some.
Well, congratulations. First one? What's that?
So first one, someone.
Well, that's great. Good luck. Tell me when you can pay these.
I feel like started next week, I can put $100 a week, that's fine.
I'll tell you what, I'm just gonna have you pay the expired plates by October 17th. That's $125, okay? And then I'll give you until October the 31st to pay the $145. That's better than $100 a week, okay? If you ever need more time, call the court on or before the due date. We'll go on Zoom, or you walk in here before the due date, 8:30, and I'll be happy to give you an extension, okay? Thank you very much. Good luck. Mr. Zelnick, okay, you got Hyatt Trucking, 25T646-282, 25T646-282A and B.
Judge, I was just enjoying the morning here. The city asked if I helped this fellow out here with his tickets, so step forward and come up there, sir. Don't tell him to be at me. He didn't come with an attorney and we're trying to resolve it today, Judge.
I got it. And your name, sir?
My name is Bill. So
he's going to plead the misload, and then they're going to dismiss the defective equipment, true?
Yes, and that's correct. And the reason is, Your Honor, he's had it repaired. He's provided proof that he's repaired, but under the commercial code, the CMV should affect his point rating in the state. The company is responsible for it.
Defective equipment. I got it. So you get to the charge of misload, sir, do you plead responsible or not responsible? I'm going to accept your plea. I'm going to dismiss the defective equipment. And $340 is your total. Can you pay that today?
Yes. So
You're all set.
Thank you,
Go
Judge.
down the home, take care of that. Have a great day. Take care, Mr. Zelnick. Masuch? Jacob Masuch? I hope I'm pronouncing that correctly. Jacob Kelly Masuch, 23T6399858 and 23T640501.
Good morning, Judge. Nice to meet you. Such.
Your name?
Jacob Mess.
Why wasn't he here all that before? What's he?
He was in between addresses at the time and moved without notifying you. Sorry.
Well, what would you be sorry about if you didn't get the notice, but you got the notice and you chose to blow us off, right?
Never received the notice.
You never received the notice. Let's see, what was on your, this was a traffic ticket that was handed to you, right?
Yes.
They gave it to you, right? Did you ever inquire? Did you think they just threw it in the garbage?
I'm sorry.
You didn't think they threw it in the garbage?
No.
Why didn't you call the court and say, hey, I didn't receive a notice? I mean, this was 2 years ago, about 2.5 years ago. He's going to plead to allowing unlicensed. I just wish they would tell me the truth instead of lying to me at the time. You know what I mean? If you plead to allowing an unlicensed driver to drive, the suspend will be dismissed. Do you understand? That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs of all those allowing an unlicensed driver to drive. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. There will not be a hearing or trial. Do you understand that?
Yes.
To the charge, allowing unlicensed driver to drive, how do you plead? On the 7th of March of 2023 at 9:35 PM, were you in control of a 2006 Dodge that was being operated on Western Pine Tree and Trent? Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
No.
Anybody in the world forced you to plead guilty? That plea is accepted, and I'm going to dismiss the suspend charge pursuant to the agreement on motion to prosecutor. So we'll talk about that sentence in a minute. Now I've got 23T640501. That is with the city of Trenton as well, but that was a different offense date. And as I understand, he's going to plead guilty under the Homes Youthful Trainee Act to assault or assault and battery. True?
Correct.
Is that what you want to do, sir?
Yes.
If you do that, the possible penalties are up to 500 fines, 93 days jail, costs are all those. Do you understand that?
Yes.
And then I'll defer the proceedings, set terms and conditions. If you're compliant at the end of the specified period of the case, you'll be dismissed. Do you understand that?
Yes.
And on these files here today, did you sign, read, and understand an advice of rights form?
Yes, sir.
That's in file 985A. You understand if you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right. Any questions?
No.
To the charge assault or assault and battery, how do you plead?
Guilty.
On November 12th of 23 at 9:52 in the morning, were you at 3350 Edison in the city of Trenton, County of Wayne?
Yes.
Did you get in a fight or assault somebody?
It was all the case.
Who was the altercation with?
Adam, Forrestal.
Anna who?
Forrestal.
Forrestal?
Yeah.
What happened?
It was a family disagreement. Me and my girlfriend at the time, we were living there, and there was an altercation between animals. There was 3 cats. They were using the restroom. My daughter played them, and my girlfriend at the time moved the cats upstairs into the bathroom with the litter box with prior intentions to moving the cats before, in the morning so we could let them out. And they got up before us and caused a scene through the whole house.
Let's forget the cats for a second.
That's what leads up to it though.
Okay. I want to get to the point.
If I may, it was explained to me that his ex-girlfriend got into an argument with her mother, who was married to the homeowner, the alleged victim here, Judge.
Adam Forrestal.
Yes, and while they were arguing, the defendant here came upstairs to set something straight with regard to some of the allegations that were thrown around. Mr. Forrestal told him not to get involved. There were some words exchanged between both of them, and there was some physical contact.
Well, that doesn't. Did you initiate the physical contact?
Yes,
What did you do?
very much, like more or less restrained them from hitting me.
You initiated that.
Yes.
Had he threatened to hit you before that?
No.
You just decided to bear hug him.
In the rate that he was coming towards me, I knew
Did you feel like you had to do that to defend yourself? If you did, I'm not taking his plea. I mean, I don't want to hear this altercation. I don't want to hear about cats. I just want to know what happened. If the defendant felt threatened, if he's telling me that the victim came toward him and that he bear hugged him in an act of self-defense, that's one thing. That's that I'm not taking the plea, and I don't care if he pleads guilty or not, but if that's not the case, I want him to tell me that.
Judge, the way it was explained to me that he was.
I want him to explain it to us. I want him to explain it to
Explain
us.
to the judge.
I want you to listen to me. I want you to start over. I don't want to hear about the cats. You're upstairs, right? All right. And there's some kind of an argument between the victim and your girlfriend's mother.
Yes.
And he is going out with or in a dating relationship. Wait a minute, slow down. Mr. Forrestal here is dating or in some kind of relationship with your girlfriend's mother, right?
Yes.
And then you hear some things and you decide you want to go up there and set the record straight, is I think how you put it.
I went upstairs because my name was involved and I had nothing to do with the situation. So I went upstairs and asked for my name to not be involved in the situation that I had nothing to do with it.
Okay, then what happened?
He took it as an offense to his wife. He told me to not say anything to his wife. I tried to explain my situation through the window in the kitchen. Couple more words got exchanged and he came charging at me from around the kitchen.
Man, I can't take this plea. If somebody's charging at me, I got the right to bear hug them, to stop them from assaulting me. I cannot take this plea in good conscience. You guys can go back and figure out whatever you're gonna do. And then either way, come back in front of me here, okay? There's just no way I can take this, not based on what he's telling me. Okay? Thank you.
Judge, can I have that?
Yeah, John. Hand Mr. Gates that file, will you? Tamaya Hopkins, rather, I'm sorry. Tamaya Marie Hopkins, 25G306557A and B.
Full story. Good morning, Your Honor. Mr. Shank, from you guys, my understanding is fine. You get left.
Ma'am, your name, please? Does she stand mute and wait